All right, good morning, everybody. Thank you for joining us and welcome to the University of St. Thomas School of Law Journal of Public Policy and Law, Law and Public Policy, excuse me, Spring Symposium on the Immigration and Refugee Crisis. I'm excited to be here. My name is Austin Northagen. I've been the one communicating with you all and all the speakers and all the attendees. So thank you for joining us today. We're really excited. And to my left here, we have Dr. Reed and our editor-in-chief, Taylor Daniels. But before jumping to them, I do want to tell our general panelists that if you're not speaking at the moment, you can turn your cameras off just to help our attendees figure out who's speaking at what time. And once I let you know you'll be speaking, you can turn your cameras back on. But for the moment, if you're an attendee, if the speaker, you can turn your camera off. And with that, we'll start with Dean Nichols to give us our welcome.
Thank you so much, Austin. Welcome to everyone joining us. A special welcome to those of you who are speaking today. I'm really grateful that you are with us, that you've devoted your time and energy and some of your passion to join us and share your thoughts with us today. For those of you who are joining as observers or who may watch this later, welcome to you. I want to start especially by thanking Austin and Taylor and Dr. Reed for the work that they've done assembling this. I know an awful lot goes into this. I want to thank our tech team who is helping to host this today and all the others kind of behind the scenes. So one of the things that I get to do that is really fun is to lead off and welcome you from St. Thomas. It's a little funnier from a Zoom screen, but let me try it this way because it fits, I think, as I was thinking about my remarks in the context of the symposium, the welcome really fits because one of the things that I like to say to everybody is, especially when you come in the building, I hope that you kind of almost feel that sense of welcome. In the Catholic tradition, we've got a deep sense of hospitality is the word we often use for welcome and inclusion. It's one of the hallmarks that we want to present here at the law school. And as I talk to admitted applicants and new people to our community, I'll often even hear back from them resonances of the way that they just felt included from the beginning. When they walked in the building, they knew this was a place for them. I hope that even on the Zoom screen, you feel and experience that hallmark of our hospitality through your interactions with each other, the engagement today, the way that you have been working already with Austin and others, Dr. Reed. I can extend that one more as I think about the topic for the day, because this sense of hospitality really sits at the core of a lot of issues around the immigrant, the foreigner, the refugee, the migrant. What does it mean and what does it look like to really include and welcome others into communities where we are? That could take a lot of different forms. One of the risks that we have at law is we set up rules and we think that this is prescriptive and that means one set thing. And so I appreciate that we're going to dig into a little bit the different ways of instantiating and thinking about welcoming and taking care of all of the members of the community, whether they're new to us or have been here a long time. But that sense of hospitality, I think, infuses a lot of what we're doing today. The one other piece, as I was preparing for today that I was thinking about again, is one of the things we talk about often at St. Thomas that relate to the mission of who we are as a Catholic institution is the respect for human dignity at the core. The human dignity that inheres in every single individual, that we see them as a whole person in themselves, not as a member of a group, not as the other, right, but as having the same dignity that I have and that you have. As we think about immigrants, refugees, and others, that comes again to the fore. How do we respect who they are, the life experience that they bring, what they might bring to our community, the struggles that they have, and how do we turn that toward ourselves? How do we see in that other person the same things that are in us, the ways that we don't shape our own circumstances, and yet we do have some influence on them, the ways we don't control are when we grow up, but that we're responding, but that we are responding to each other, hopefully out of our most generous selves, out of love, out of compassion for one another, out of assistance for each other. But it sounds like I'm only focused right on the one who is coming in. That human dignity inheres in those who are already present. And one of the struggles that we have, that law faces, is how to allocate resources that are too scarce among those who are coming and among those who are already here. And that divide or that sense of scarcity often creates these separations, these walls between us. So one of the things that we'll be thinking about and that is on our mind at St. Thomas is, when we talk about human dignity, how do we think about the different facets of each person that is present? The last piece I'll just share as I'm thinking on this is, you're going to all be bringing these perspectives of how law itself comes into these notions of hospitality and human dignity. How does the idea of law, whether domestic state law, whether international law, how does it inhibit these concepts? How does it interact with it? How does it shape it? How can it help it grow? So I'm really looking forward to a great symposium today. There's a great lineup of topics and speakers. So thank you again all for being here. I look forward to hearing more as the day goes on.
Wonderful. Thank you so much, Dean Nichols, for taking the time and giving us a warm welcome. I'd now like to turn to our editor-in-chief, Taylor Daniels. Joel Nichols, you can turn your camera off if you'd like, and we'll move over to our editor-in-chief, Taylor Daniels.
Hello, everyone. Good morning to those of you in the Western Hemisphere, and good afternoon and evening to those of you on the other side. I would like to welcome you to our symposium today, and thank you for joining us. As Austin said, my name is Taylor Daniels, and I'm the editor-in-chief, and I have been so lucky to serve in that role over the last year. We have a really great team here, and they've worked really hard to make today go off with as few hiccups as possible. So as we've discussed a few times already, our topic is the immigration and refugee crisis. And when we were talking about what topic we wanted to cover, it was really something that we were trying to think could focus on, as Dean Nichols was discussing, the human dignity and how to uphold that in whatever aspect. And so we came across this topic, and here we are. The speakers in today's program are very uniquely placed in panels for you to analyze and better understand their key points, trends, reforms, and general concepts as a whole. So it's going to be great to hear from our speakers about how the realities of migration are influenced differently across the world. And before we begin, I would like to acknowledge Xander Mose and Rick Hendrickson, who are making today possible for us all to join virtually and keeping us connected as the day goes on. Thank you for your work. And I will probably be thanking a lot of people throughout the day, as I would assume others would be as well. But I really think it's important that we give credit to where it's due for people that really put in a lot of work and spend time working on things, especially when you're not as technologically savvy as our friends Xander and Rick. So thank you for that. I will pass it over to Dr. Charles Reed. He is our faculty advisor to get us started.
And good morning. And I would like to build on an observation that Dean Nichols made, and that is the Catholic approach to immigration. Pope Francis, the beginning of his pontificate, made it a point to travel to Lampedusa on the Mediterranean coast, where he mourned the death of hundreds of thousands of immigrants trying to seek a better life in Europe, traveling from Africa. Immigration, the refugee, is a central feature of his pontificate, should be a central feature of of our moral lives and should finally be a central feature of public policy. That's a major purpose of this symposium, to develop policy responses to a global crisis, to a crisis that has been made worse in the last 18 months, 12, 18 months, with the war going on in Eastern Europe between Russia and Ukraine. We see, I believe, 8 million refugees caused by that conflict alone. We have conflict in the Middle East, conflict in Eastern Europe. We have a worldwide immigration and refugee crisis. And we hope in some small measure, to propose policies that might relieve these burdens, ameliorate this tragic worldwide crisis, and come to a more just and safer world. I'd like, before we launch into the program, I'd like to single out particularly the student editors of the Journal of Law and Public Policy. Austin Northagen, who's the symposium editor, is on my right, and Taylor Daniels, the editor-in-chief of the journal, is on my left. They have done wonderful work in keeping the symposium on track, keeping the journal on track. The Journal of Law and Public Policy is enjoying banner success, and it's because of the wonderful contributions made by the student editors. So I'd like to make sure to thank both Taylor and Austin. And with that, I believe we, Austin, are we ready to begin?
We are. Yes.
And let's begin.
Wonderful. So for all the speakers currently online, when I call your name, you can turn your camera off and you can unmute. If you, oh yes, you can turn your camera on, you can unmute yourself. My apologies. And otherwise, if you are not speaking, if you're not presenting, please keep your camera off. Please keep your microphone muted. And if any attendees have any questions, or if any panelists have any questions, you're welcome to put those in the chat at any time. How we typically run these is we will have each panelist present their topic, and then at the end we will have group questions for all three panelists. But if there's any immediate questions, please throw it in the chat, and we can do our best to answer it. So with that, I will get started with our first panel. On our first panel, we have Mr. Cholt Mate. Mr. Mate is a Pro Ciencias gold medalist, two-time winner at the Countrywide Scientific Student Conference, a PhD student at the University of Pete's. His current dissertation is about the American, Canadian, Australian governmental relations to the 1956 Hungarian Revolution and refugee crisis. He has participated in immigration and refugee conferences around the globe, including Hungary, Canada, and France. Lastly, he is also a published author of a Hungarian-German bilingual science oral history book about the 1956 Hungarian refugees in Graz. Secondly, we have Chelek Koka. Dr. Chelek Koka currently serves as an associate professor and is the chairman of the Democracy and Law Studies Association. He graduated from Mara Mara University Faculty of Law in 2008. Dr. Koka started out at Adana Bar Association, serving first as an intern and then as a lawyer. Between 2013 and 2022, he has worked as a research assistant in Ankara University Faculty of Law's Department of Public Law. Dr. Koka holds both a master's degree and a doctorate from Ankara University, graduating in 2022 with his PhD thesis titled Slavery, Enslavement, Crime, and Human Trafficking Under International Law. Dr. Koka has also completed extensive research on immigration, refugee rights, international criminal law, human rights, and the prohibition of use of force under international law. And the last panelist we have for the first panel is Sylvia Mazar. Dr. Mazar is an associate professor in the Department of Public Policy and Governance at the University of Information Technology and Management in Poland, a Kaziako Foundation Scholarship recipient. She received her PhD in European Union law and her Bachelor of Science in Journalism and Social Communication. She has graduated from a number of other training programs, including Odyssey Network Summer School, European Academy of Diplomacy, International Business and Trade Summer Law Program, and Europe in the World Global Governance Training. So there's a little bio about each of our first panelist speakers. And with that, we'll start with Mr. Cholt Mate. So you can turn your camera on and unmute yourself. And if you have slides to present, you can go ahead and share those.
Good morning, everyone. Thank you for the opportunity. It's a pleasure to be here with you, and I feel very special that I can be the first one at the conference and be able to talk about the major chapter of my dissertation. And I hope to this conference, which discusses mostly current topics, with my historical presentation, I can participate in the discussion later on. So I will talk about how these three countries can be role models for today, or how these three countries received Hungarian refugees in 1956-57, because all these three countries are special, not just by their size, but also by their approach to the refugee reception process. But first of all, I'd like to talk about how the refugees ended up all around the world. Because not only Canada, Australia, and Australia received these refugees, but as you can see from this United Nations report, that many other countries wanted to receive Hungarian refugees at the time, because it was the word prestige to receive refugees, get good points in the view of the American diplomacy that we are willing to accept Hungarian refugees, even if it's just one or two, like in the case of Cyprus or in Cuba. But that was a big gesture towards the Hungarian refugees. How many are these overall? Almost 200,000 people left Hungary from mainly November of 1956 till middle of 1957. And they went from Hungary to Yugoslavia or to Austria. Only 10% of these 200,000 people went to Yugoslavia, to south from Hungary. And most of them went to western direction towards Austria. Both of the countries used this as a big step in their foreign policy, because Austria became independent only a year before, in 1955, and Yugoslavia wanted to position itself in a higher level in their diplomacy by holding up the refugees, asking for help from the United Nations, and getting as much funding and help what's possible. Because for Austria, it was like a big competition from Western countries who helps the most. So for example, Switzerland in the first couple of days already arrived with trains to the refugee camps, and they get many thousands of refugees too. And also many countries provided help in an economical, financial way, or just by providing coal or edible goods to Austria. It's a refugee crisis in the way that 2% of the Hungarian population left Hungary in a couple of days, in a couple of weeks. And also for Austria, they received 2.5% of their population in a matter of weeks. So this big influx of refugees made many infrastructural problems. For example, the regions of Austria, which ones are closer to Hungary, had to suspend the school here because that many refugees came that they needed to use the schools for a couple of days. But after all, from Austria and Germany, many of these refugees could go abroad, and they could choose where they want to go. because all these countries had to change their policies about receiving refugees. The most popular destination among refugees was the United States of America. Most of them wanted to go there because they had relatives from the Second World War immigration, or from the beginning of the century, or just because the cultural influence of the United States towards Hungary in the Radio Free Europe. It showed that they have a good place there. The American approach to the Hungarian refugees was a very centralized and very efficient and very quick response, because Eisenhower already announced just after the presidential elections at beginning of November that they are raising the quota towards Hungary. Previously, it was only a few hundred every year, but by middle of November, it was 5,000 people who could come from Hungary. But due to the huge interest, they used a hole in the regulations where American missions can provide visas to the US on parole, which means that later the refugees can get their visas in the US. So this on parole arrival helped almost 40,000 people to get to the United States, and two-thirds of them arrived in a governmental program and operation. The US Army organized two operations. The first one was the Operation Safe Haven, and that had two phases, and that transported Hungarian refugees by plane or by sea to the United States. And there was also the Operation Mercy, which reorganized an empty and abandoned military camp in New Brunswick, New Jersey. And they set up the Hungarian Refugee Reception Center. You can see the entrance of the refugee center on the picture. And all the refugees had to go through that location. All the major regulations like medical checks, tax documentations, job interviews, everything was organized there. And whoever had their sponsors or families nearby, they could leave the camp in a matter of days. Some of them who didn't have a place to go had to stay a little more in the Camp Kilmer. Also, Camp Kilmer was chosen because there's a Hungarian community nearby. In New Brunswick, many pharmaceutical companies employed Hungarian refugees, and also they helped the Hungarian refugees, not just the American army. Also, it's important to highlight that even the US foreign policy was not to support militarily the Hungarian Revolution, the Hungarian uprising. The American society felt emotional, and they wanted to solidarate with the refugees. And that's why the huge amount of donations asked and ordered Eisenhower to establish the American Presidential Committee for Hungarian Refugee Relief. So a whole committee organized the reception of the many funding and many donations what the Hungarian refugees received from the American society. And from this approach, you can see the American reception process is very centralized. Also, the Hungarian refugees influenced the American immigration policy in a longer term. So, for example, by the documents, what I found at the John Fitzgerald Kennedy's library, presidential library, they already started the reform of the immigration policy, and the Hungarian refugees and the Taiwanese refugees were the two reasons which showed that in critical times, the yearly quota system is not working for the US interests, because they have to use these loopholes to be able to receive many refugees. That's why one of the reasons was to modify the American immigration policy. Canada had a huge immigration policy since the beginning of the century to fill up the huge lands, mainly on the northern and western side. And Canada organized several trips to Austria to get the best of the refugees. That's why, for example, the educational minister had a trip to Vienna at the time. And Canada became also one of the only countries with Australia, who received refugees after 57 till 1960s from other countries. So if someone didn't really like the weather of Ireland or wasn't satisfied with the Netherlands or Italy, they could choose the Canadian embassy, and Canada gave a second chance to these Hungarian refugees. With that, they almost equivalent to the American refugee number by the time of 1960. Also, Canada had an immigration, organized immigration on a high level, on a ministerial level, but the reception process was provided to the territories of Canada. And that's why the Canadian immigration could start it only later in November, because all the territories and leaders of the territories had to agree how to accept the refugees. That's why in some places there were no reception centers. They just used an abandoned prison or set up camps nearby train stations. And also that's why refugees didn't get the same effect after arriving to Canada. Also, that's a big difference with Canada and the US, that quickly in beginning of 1957, the new Hungarian communist regime started the repatriation. So they asked the refugees to return to Hungary. The American government opposed this approach. They did everything what they could not to let the refugees go back. And the Canadian government was not against. And that's why one of the highest number of repatriation is from Canada. And also the Canadian approach was mainly financed through the Red Cross of Canada. And to the end, Australia was in the highlights of 1956 because they hosted the Summer Olympic Games. And also they had a big immigration policy, which was in favor of the Hungarian refugees. It was called by White Australia. They received refugees only from European countries. And that was already a liberated regulation after the Second World War. Australia used immigration agents in Europe, which visited the camps of Austria and Yugoslavia. And most of the Yugoslavian refugees ended up in Australia. This also made the Hungarian community in Australia 10 times bigger because they had such a effective immigration approach to the Hungarian refugees. Australia was also very unique in the way that the refugees had to sign a contract with the Australian government, which said if they want to leave Australia in 10 years, they have to pay back their transportation fees. All the US and Canada didn't have this approach. And also from all the countries, Canada and Australia, they just needed a shot against smallpox and the disease of the age. Australia needed an X-ray of the chest too to be able to step on board of a cruise ship. Canada and Australia used regular passenger ships to cross the oceans. And that's why Canada and Australia didn't organize that well-handled military support to the Hungarian refugees. So they used regular passenger trains to get to the ships and regular ocean liners to get to their new homeland. But Australia had their own reception center called Bonegilla. That's where the refugees had to spend a couple of days and they get their papers done. And that worked as also a quarantine. That was close to Melbourne, and they used it since the Second World War. That wasn't unique just for the Hungarian refugees. That was a general approach that the new immigrants to Australia had to go through Bonegilla. And just to end up my presentation, I would like to highlight, if you are interested in the Hungarian refugee and the Hungarian refugees, hopefully in 1 or 2 years, this book, what's covered is on the right side of my slide, will be translated to English. And that's a handbook of the Hungarian refugees with case studies of the refugees and also country chapters. So there will be studies of how specific countries accepted Hungarian refugees all around the world. Thank you very much for your attention.
Thank you so much, Mr. Mate. You can now turn your camera off and mute yourself, and we will go to Dr. Koka from Poland, Turkey. Turkey, my apologies. That Poland's the next speaker. So Dr. Koka, you may now share your screen if you'd like. Otherwise, you can start when you're ready.
Yeah, thank you very much. First of all, I would like to thank organizing committee of this symposium. It's a real pleasure for me to be part of the symposium. I will talk about Turkey's safe zone policy in northern Syria and its extraterritorial obligations. First, I would like to give a small info about the civil war in Syria. The conflict in Syria began in 2011 and turned from a largely peaceful uprising into a civil war in a short time. With the start of Syrian civil war, more than 6 million Syrians have fled the country, moved to other countries like Turkey or European countries or Jordan. And I would like to also mention that 6.7 million Syrians are internally displaced. Now, Turkey hosts the largest number of refugees in the world with 3.7 million people. From this, 3.5 million is Syrian asylum seekers in Turkey, and also Turkey is hosting asylum seekers, refugees from other countries such as Iran, Afghanistan, or Iraq. Turkey doesn't give official refugee status to Syrians and give them temporary protection status, which gives similar rights to the refugees. The reason behind this policy is Turkey wants refugees to return back to Syria when the civil war ends. And also Turkey has a geographical reservation to the 1951 Geneva Convention. According to reservation, only people coming from Europe can be granted refugee status. Turkey is already hosting 3.5 million Syrians, but there is still huge risk for more Syrians to cross border and enter the country due to political instability and ongoing armed conflict between different groups. Turkey has implemented 3 military operations in northern Syria with the support of Syrian National Army, which was called Free Syrian Army before. They are composed of opposition forces against Assad regime. Turkey, with these 3 military operations, Turkey created a safe zone for asylum seekers, and Turkey also aimed to fight against terrorism. The first operation was called Operation Euphrates Shield on 2016. The second one is Operation Olive Branch on 2018, and the last one was Operation Spring Shield on 2020. The safe zone aimed inter alia to encourage voluntary return of Syrian asylum seekers who are in Turkey and prevent new ones to enter the country, new ones to cross Syrian-Turkish border. Because Turkey claims that it would have a destabilizing effect both in the region and in the country to accept more refugees. Now, the Turkish controlled areas of Syria is more than 8,000 square kilometers, covering more than 1,000 settlements. And also this area includes cities such as Afrin, Elbab, Azaz, Jerablus, and Tel Abyad and Resulayn. Most of these settlements have been captured from ISIS or Daesh and the Syrian Democratic Forces. These two organizations are accepted as terrorist organizations by the Turkish government. In these Turkish-controlled areas, more than 2 million people live, since the majority of Syrians in this safe zone escaped from the violence of Assad regime. And if Assad regime comes back to this safe zone, if Assad regime comes back to this area, their security will be under threat again. If we talk about Turkish situation for the Geneva Convention and 1967 protocol, Turkey is a state party to these conventions with geographical reservation. In principle, refugee conventions application is territorial. Interception of asylum seekers before they enter state territory, which is an extraterritorial activity, may not exempt a state from its obligations under international refugee law and human rights law. When asylum seekers come within the jurisdiction of a state, that state will be obligated to ensure that some rights are guaranteed. Establishing effective control counts an exercise of jurisdiction that leads to international responsibility. The general meaning of effective control has been described as, has been developed in several cases by different international jurisdiction mechanisms like International Court of Justice. The general meaning of concept can be described as an intentional display of power and authority over the territory by the exercise of jurisdiction and state functions on a continuous and peaceful basis. International Court of Justice has several judgments about this concept. European Court of Human Rights also has decisions, judgments on the concept of jurisdiction. European Court of Human Rights confirmed that the concept of jurisdiction was not restricted to the national territory of the state, contracting state. European Court of Human Rights confirmed this in the case of Luizidu versus Turkey on 1995. In particular, the court said that state responsibility might also arise when, as a result of military action, this can be lawful or unlawful. The state can exercise, when the state exercises effective control over an area outside its national territory. States' obligations to secure in such areas the convention rights and freedoms derived from the fact that they exercised effective control there, whether that was done directly, which is states' armed forces, or indirectly, like paramilitary groups or local administration. In the Luizidu case, the individual from South Cyprus started a case against Turkey because of the loss of her property which stayed in Northern Cyprus. European Court of Human Rights accepted this claim and took Turkey accountable for its military action by exercising jurisdiction in the Northern Cyprus. According to international law, Turkey is exercising jurisdiction in safe zone in northern Syria. Turkey has military presence, police stations, provides infrastructure services, opened post offices in the controlled areas, and in northern Syria, Turkish lira, Turkish currency is being used as so-called official money. Turkey has also appointed vice governors of border cities, Turkey's border cities, to be responsible for districts in northern Syria. As a result, we can say Turkey has responsibilities under international human rights law and international refugee law. I would like to mention that safe zones may be the best outcome for people otherwise trapped in conflict zones, but that's all. The law on safe zones is underdeveloped, and state practice is too erratic and random for them to be considered a proper response to humanitarian crisis. To succeed, safe zones must have a civilian, humanitarian, and neutral character, and humanitarian actors, international organizations must have access to people who are living in safe zones to ensure protection through respect for international human rights and humanitarian law, and to facilitate delivery of relief and assistance. I would like to say that safe zones do not provide true protection under international refugee law, but it's still important to underline countries' state obligations outside of their territories. So Turkey has obligations under international law. Turkey has to provide some rights. Turkey should guarantee the minimum rights in the safe zones, such as, but not limited to, the right to life through the principle of distinction, the right to be free from torture and cruel and inhuman or degrading treatment or punishment, freedom from arbitrary recruitment to participate in the conflict, personal security, particularly in relation to sexual and gender-based violence, the right to highest attainable standard of living and health, access to humanitarian relief and assistance and access by humanitarian organizations, and maybe the most important one, freedom of movement, including the right to leave the country and seek asylum with full respect for the principle of non-refoulement. So we can say that when Syrians came to the northern Syria, Turkish-controlled safe zone, Turkey shouldn't send them back to the areas controlled by Assad regime. Relying on safe zone to prevent persons from seeking protection would be contradictory with international law, especially the principle of non-refoulement. Besides this, safe zone does not provide a complete solution to the problems and should never be seen as a place to which refugees can be sent back. So Turkey shouldn't send refugees, asylum seekers who are already living in Turkey to the safe zone. And when the people come to the safe zone, they should not be sent back to the Assad regime controlled areas. So this is more or less my presentation. I would like to thank again for inviting me as a panelist. Thank you.
Wonderful. Thank you so much, Dr. Koka. We're very grateful to have you zooming in from Turkey and to hear about your reflections and thoughts on Turkey's current policies. You can now turn your camera off, mute yourself, as we will turn to our third and final panelist for this panel, Dr. Mansar from Poland. Thank you to have you as well. And you can share your screen or start your presentation when you're ready.
So a little correction, since this academic year, I'm affiliated with the Research Center for the Future of Law at the Catholic University of Portugal. But like Austin mentioned, full disclosure, I'm Polish, and that's where I actually got my degree. So today I would like to, and yeah, in connection to Dean's word, I would like to very much thank you for your hospitality, because I know that it was on a very short notice and I was a little bit late. So thank you for allowing me to participate in the event and to publish. Today, I would like to talk about human rights violation that happened during a standoff on the Belarus-European Union border. And I want to give it a legal perspective because what this crisis showed is that we are dealing with the constant deterioration of refugees and asylum protection rights in Europe, especially in Eastern and Central Europe. So the plan for the presentation is that I will talk about my motivation. I will also highlight some main points of the relations between European Union and Belarus because it very much influenced the crisis. And I will talk about the notion of migration instrumentalization, which happened more and more often. In a second part, I will talk about the response by the European Union as a whole, because as all of you know, Poland is a member of the EU since May 2004, and a part of the law regarding asylum law and migration law is the EU law. Then I will talk about affected member states' action, namely Poland, Lithuania, and Latvia, and of course Poland will be my main point of interest. However, we have to look at the crisis and everything that happened starting August 2021, May 2021 as a one. And I will then focus on violations on Poland's authorities' part. So I will try to highlight what happened on the border. I will also mention the stark contrast between actions taken by Polish authorities toward Ukrainian migrants, Ukrainian asylum seekers, Ukrainian refugees, and everything that happened a little bit up to the north with people that crossed the border with Belarus. And I will finish with conclusions. Just my apologies, like I will try to be as quick as possible. So I hope that like my legal analysis will be better presented in the written paper. However, I will take all the questions. So why I decided to focus on this crisis is because it happens to be a forgotten crisis. Why is that? So as you probably are aware, in 2015, European Union was shaken by one of the most serious crises in its history, migration crisis. It did not happen at once. It was a crisis that was evolving. However, in April 2015, during one night in Mediterranean, almost 800 people lost their lives, and with that, the EU decided to act. Of course, the solutions were very weak. Dominated like ad hoc solutions. There were also measures which were not used, and this is the questions why they were not used. However, the scale of the conflict, the scale of the crisis from today's perspective was not that big, because like we assumed that it was 1,300,000 people that crossed, that entered the EU territory during that crisis. And yeah, but we have to at the same time remember about the amount of refugees that after that the war in Syria started, that went to Turkey, for example, all other neighborhood countries. So the crisis in 2015 was mainly institutionalized crisis, like EU states could not deal with it as a once, and of course the solidarity component was highly missing. The crisis, which I will talk about today, started in 2021, and I will tell more about that and the beginnings of that crisis. However, everything that happened on that border was very quickly covered by the Russia's unprovoked attack on Ukraine and the mass influx that happened, that started in February 2022. So the hospitality, the welcome culture of the European countries was in a stark contrast to everything that happened on the border with Belarus. Now, just to give you a little bit insight, the crisis, that everything that happened on the crisis with Belarus was called anything but like migration or refugee crisis. So there were different terms to use it. So here you have in the first bullet, you have a sentence: this is not a migration crisis. This is the attempt of the authoritarian regime to try to destabilize its democratic neighbors. So surprisingly, those are not words of Polish politicians who very often politicize migration. Those are the words of Ursula von der Leyen, the president of the European Commission. Then it was called an artificial migratory movement. It was called a security crisis. It was called hybrid warfare. So all those terms were used, and they, like, the layer of human suffering and everything that people went through on that border was completely missed. So those are the official statements. Those are the terms that were used. And as you can see, the human component, the humanitarian component, is missing, which is very disturbing. Now let me talk a little bit about the relations between European Union and Belarus. Belarus is the state which I point to with the red arrow. So as you can see, Belarus has a border with 3 EU member states. It's Poland, Lithuania, and Latvia. And the yellow border, the yellow line you see, this is the border of the Schengen area. So this is so-called external border of Schengen area, because as you know, in Schengen area there are no internal borders. However, the states that are having external borders of the Schengen area are responsible for protecting those borders. So as you know, when the transition in the Central and Eastern Europe happened in the 1890s, Belarus was that state that did not go through that transition, and it was still an authoritarian state. However, relations were, although they were complicated, the situation seemed to settle, and in fact, even improved between 2015 and 2020, because after Lukashenko released political prisoners, there was some loosening of sanctions, and also at that time the restrictive measures were lifted, the political dialogue was enhanced, and there was increased financial assistance. And here I also have to mention that the EU was giving money to Belarus authorities, and between 2001 and 2012, Belarus received 47.5 million euro, and those are money that were dedicated for protection of borders. So this is actually a thing that is more and more common in the EU, that is incentivizing the external, it's a sign of externalization of the migration policy. So third countries, when I say third countries, I mean states that are not member of the EU, are receiving money in order to prevent those mass influx to happen. And this is a topic for completely different discussions. However, what I'm trying to highlight with that is that the relation was good enough, and the money were set. Plus, apart from those 47.5 million, Belarus received almost 20 million euros for different projects. Now, everything changed in 2020 because during presidential election, the results of presidential election in Belarus were not recognized. The election were not fair. Of course, according to the official results, Lukashenko won. However, EU did not recognize the results of those elections. And from that moment, the situation started to deteriorate, especially that Belarusian people started to show the signs of their unsatisfaction with the government, to put it mildly. A lot of them were arrested. A lot of NGOs were delegalized. So situation in terms of human rights was very, very quickly deteriorating. So from that moment, the EU started to impose restrictive measures in response to development. And however, it was not enough, because like Belarus was still acted in that rock way. So in May 2021, 2021, the plane with one of the human rights activists, one of the journalists, was actually forced to land in Belarus, and that activist, Roman Protasiewicz, with his girlfriend, were arrested in Belarus. So that was the peak, and obviously at that time the EU as a whole lost its patience with its neighbor. And the situation escalated because then in June 2021, Belarus suspended its participation in the Eastern Partnership, which is a project created by the EU, initiated by Poland and Sweden. It was a project that was created in order to facilitate communication and facilitate political dialogue with the Eastern neighbors. So Belarus withdrew from that partnership, and also unilaterally withdrew from the readmission agreement. So readmission agreements are agreements that the EU is signing with third states in order to return people that are crossing EU borders in an irregular way. Now, about instrumentalization of migration policy by Belarusian authorities. So this is not a new phenomena, and we could observe that in the past. So what Lukashenko did is, like, in May 2021, he signaled that he will float EU with migrants and drug, and that EU member states will have a problem with that. And very quickly, everyone realized that this is exactly what he will do. So in May, June, we started to see the first crossings from people from Middle East. So generally, the process was facilitated from Minsk, Belarus. So the prices of tours for people coming from that part, from Middle East to Belarus, were decreased. Number of flights was increased, so more and more people could come. Visa regime was loosened, so that means that people coming to Belarus could get visa after landing, so they would not have to apply in their home state. They could do that once they land in Europe. And of course, they were promised that they receive a lot of information on social media that it is possible and it is legal for them to cross Belarus border with EU states. And after those migrants were coming and after they landed, they were receiving instructions coming from Belarusian authorities, and they were pointed to the border. First, it was with the border with Lithuania. So in June, we saw late May, June, we saw the first crossing in Lithuania. So in August, there were already 4,000 people in refugee camps on Lithuania territory. However, Lithuania very quickly started to protect its border and actually showing reacted very quickly. So from August, the flood of people was created toward Poland. What happened at that point, the response of Polish government was very, very quick, and Poland said that it will not accept any migrants, even if they claim that they have every right to apply for asylum. So that was very clear for the beginning. In order to present itself in a little bit better light, Polish government offered a humanitarian aid for the migrants, like tents, like sleeping bags, and so on. But of course, it was rejected by the Lukashenko regime. And also in November 2021, the situation a little bit changed, because in November, after seeing what's going on, Lukashenko allowed some migrants travel back to their home countries, especially those that were stranded in Belarus and they could not cross borders. So what was the EU response as a whole? So the EU agencies were involved in help. So it's a Frontex border agency, European Asylum Support Office, and Europol deployed officers and experts, which provided technical equipment. But there is a caveat to that. Poland did not agree for Frontex officers to be deployed, which is a little bit paradoxical because Frontex is an EU agency and it has its headquarters in Warsaw. So the headquarters was actually put there in Warsaw because there was some expectation that sooner or later there might be an influx of people coming from eastern side. However, Polish government completely refused any kind of help coming from the EU level. The Union Civil Protection Mechanism was activated, so this is a relatively new mechanism that helps people in catastrophic situations, also human-made situations. There were also some EU laws loosened in order to prolongate the possibility for a state to for the extension for the registration period for people coming, and also there was some kind of the threshold for material reception conditions were lowered, so it just only to cover basic needs. And the application process was simplified. Also on an EU level, we could see actions taken toward dialogue with states that migrants, asylum seekers were coming from. So that is why the dialogue was maintained and it was conducted with Iraq and other Middle East countries. And also there was a plan to introduce provisional emergency mechanisms. So this is a mechanism that was established, that the proposal, because it never entered into force, the proposal was based on Article 78 of Treaty on Functioning of European Union. So some of you might have heard, especially my colleagues from Europe, might have heard about this article, because this is the article based on which the temporary emergency mechanism during the 2015-2016 was introduced, in order to relocate 160,000 people from those vulnerable states like Italy and Greece. But as you know, the mechanism then was a complete failure, and in this case, it also was not introduced. So the legislative process stopped before ever entering into force. So the EU response toward Belarus was a very quick condemnation on a political level, and like I mentioned, any kind of support was very quickly suspended. And also the sanction regime was enhanced, so there were new sanctions introduced. And assistance for stranded migrants was, in financial terms, of course, the number of money is ridiculous. However, like I said, countries rejected the help coming from the EU. What was the response from those member states that were affected? So the three I mentioned, Poland, Lithuania, and Latvia, they quickly declared a state of emergency, and they also announced their decision to build border walls. So this is something my American colleagues might be familiar with, and this is an international trend. And just to give you some numbers, in 2014, the number of the line of the walls in the Schengen area border was just 315 kilometers, right? And in 2022, it was already more than 2,048 kilometers. So as you could see, more and more states, especially those having external Schengen zone border, are actually creating those are building those walls. Now, this is a very highly controversial idea due to different reasons. However, 12 other member states, apart from those three, supported the idea. However, there is still no the decision to fund building a wall from the EU funds was not green-lighted. So far, European Commission has been steady about that. They said EU funds should not be used to build a wall between the EU member states and third states. Poland and Lithuania also marked so-called red zone, especially in Poland. It was one of the measures that was highly controversial, because no journalists and no humanitarian workers and what's even worse, no doctors were allowed to enter that red zone. So it was not only in order, like the support and assistance for people crossing border could not be delivered, but at the same time, there was no accountability. We could, like, people could not know what's going on there, and no information could be collected. What's even more worse, like Doctors Without Borders left Poland because they were not allowed to enter the red zone in order to help those people that were stranded there. And Lithuania also introduced a financial measure that people that would decide to go back to their countries, they would become a voluntary returnees, would receive 1,000 euro of payment, which is not a lot considering that the costs, very often those people had to pay much more in order to get to Europe and in order to pay smugglers. So from a legal perspective, the situation is very interesting because Poland is not only party to the 1951 convention, which was mentioned by my colleague from Turkey, and of course protocol from 1967, but also Poland is a member of the European Union. So that means that it is binded by the treaties and by the EU Charter of Fundamental Rights. So this is EU Charter of Fundamental Rights. It's an act that since the entry into force of Lisbon Treaty, EU Charter received the same legal power as a treaty. So it became a primary source of EU law. And why is it important? Because for the first time in this chapter, we have explicitly mentioned a right to an asylum for people coming from third countries. So Article 18 of the EU Charter actually explicitly mentions the right for asylum. So plus we have, of course, secondary laws. And Poland is also a member of Council of Europe. So that means that it is the party of the Convention for the Protection of Human Rights and Fundamental Freedoms. Plus, of course, there is a domestic law. So a right to grant an asylum and refugee is embedded in Article 57 of Polish Constitution. And here it's a very interesting fact that Poland keeps duality. So there is an asylum and there is a refugee. So Poland keeps those two things separate. So as you could all see, there are overlap. Of course, those regulations, different regulations, overlap with each other. However, the interactions between them is swelling, and it is already a Byzantine system. So very quickly, Poland, as you could see on the map, is a state that has an external EU border. So that means that Poland is responsible for protecting that border. And what was also confirmed with the opinions and just coming from the European Court of Human Rights in Strasbourg, states have undeniable sovereign right to control aliens in entry into their territory. So this is something that no one undermines. However, those states have to comply with international and EU law. So here you have also the decisions that were delivered in cases regarding those situations. As you can see, two of them are in connection to the United Kingdom, which is not any longer an EU state. However, the decisions are still right. Also, Schengen area has its own border code. So according to Article number 5 of that code, external borders might be crossed only at the border crossing points during the fixed time. Plus, the states are responsible for placing effective border surveillance system to prevent unauthorized entry. However, the same code very explicitly states that border control measures must be without prejudice to the rights of refugees and other people requesting international protection, in particular as regards the principle of non-refoulement, and EU countries must respect fundamental rights when carrying out border controls. And we know that it was not a case on Polish-Belarus border. So what happened? Poland decided to militarize the border area. So apart from building a wall, there was a very high deployment of 4,000 border guards and 25,000 soldiers, and also police was involved in those actions. So, as you can see, it was like a war zone. And seeing pictures from those situations, you might get a little bit dizzy and ask yourself, where are you? Are you in a Central Eastern Europe, or maybe you are in some war zone? Let me just a little bit talk about the first bullet, the refusal of Frontex deployment. So very quickly, Frontex, as I mentioned, is an agency responsible for protection of borders. And to be honest, like, there was no guarantee that in Frontex will be deployed there, everything will go smoothly and human rights will be observed. No, because as we know from the previous crisis, actually Frontex was involved with pushbacks, and especially on a Greek and Turkey border. Okay, and from legal perspective, also the worst thing that happened was that the law was amended that actually legalized pushbacks, and it was signed into law by Polish president. So actually, the head of the border guard has a right to refuse person the entry, and that person cannot appeal this decision. So this is like a clear case of pushbacks. Plus, I have to mention that government again. I say again because that would happen in 2015, again, very highly politicized the notion of migration and refugee. And there was this famous press conference where our Ministry of Internal Affairs was showing pictures which were allegedly found on a camera somewhere in the forest. And it was just, those were just like disgusting pictures of presenting person from having sexual intercourse with an animal, and also some pedophile pictures. So based on that, our two ministers were representing and stoking fears. And it was a part of the dehumanizing component, which was very much criticized and which was very disgusting. Now, in my article, I will get through those violations. So the one I will mention first will be pushbacks, and very quickly, pushback is not a legal term. However, the United Nations Office of the High Commissioner for Human Rights is giving us this definition. So those are different measures taken by states which result in forcing back migrants to return to the other side of the border, and those people are stripped of the right to apply for asylum and for international protection. So this is against, again, the Article number 4 of Protocol Protocol 4 of the European Convention of Human Rights, and those are actually, everything was confirmed by the court in Strasbourg in cases Becker versus Denmark and Hirschiyama versus and others versus Italy. Now, like I mentioned, due to the state of emergency and the red zone that was introduced, it's very hard to confirm everything that happened during that period on the border. However, the human rights organizations did amazing jobs. So Amnesty International, Human Rights Watch, and also Polish organizations like Foundation Ocalenie. Very often those people were risking their own safety because some of them, five activists were, for example, arrested, and receive the penalty of 8 years in prison for supporting human trafficking. So that's what they were accused of doing. So what happens with those pushbacks? It was like a ping pong between Poland and Belarus. What does it mean? That once people cross the border to Poland, and even when they were claiming that they want to apply for asylum, which they have every right to do, and their case have to be checked on an individual basis, still they were pushed toward Belarus. And once they found themselves in Belarus, it was even worse, because there we have proofs that there was a lot of violence toward those people, especially in a camp. So there was a lot of beating, there were some kind of tortures, and of course sexual harassment and even rapes. So those people were pushed for some times between those two countries. The asylum claims were ignored. So we also have a collection of records coming, and people claim that they have a paper where it was written in English and in Polish that they wanna apply for asylum. However, the border guards completely ignored that. So if they were close to if asylum seekers, migrants were apprehended close to the border, they were pushed toward Belarus. If they were a little bit deeper in a state, they were very often forced to sign expulsion decision, and then they were taken back to the border. Or, for example, the return for them was organized. So this is like a classic case of pushback. Another violation was collective expulsion. So this one is also regulated by the European Convention on Human Rights, plus it is regulated by the EU Charter of Fundamental Rights, which I previously mentioned. So what does it mean? It's the expulsion is like a forcible removal of a foreigner from the territory to the territory from where the person came. And collective means that there was no individual checking on the case. So in international law, every person that lodges an asylum application, the application should be checked on individual basis. But with this, those people had no chance. So even though there were people coming from war-torn countries, or people that were discriminated on the basis of their religion, like Yazidi, or their ethnicity, like Kurds, or their sexual preferences, their questions for asylum were completely ignored, and people were expelled toward Belarus again. And just to be clear, here also the court in Strasbourg decided that collective, it's enough that 2 people will be expelled without checking their application. It's already called collective expulsion. The next thing is a principle of non-refoulement. So as you know, this is one of the principles in international law, and it's very much regulated. And on your right side, you see the acts where it's being regulated. But the one I'm presenting here, it's in article number 33 coming from the Refugee Convention from 1951, which very, very clearly states that expelling or returning a refugee in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened on account of race, religion, nationality, membership of a particular social group or political opinion is forbidden. And it was very clear from the start that people that are being returned to Belarus or pushed back to Belarus, they will be tortured, they will be imprisoned, and they will be harassed. So because there was also this argument which was used that Belarus is a party of Refugee Convention. The fact that the state is a party of the convention does not mean that the state follows the convention. So the evidence was already very strong that Belarus was violating human rights, and that includes tortures, and that includes endangering of life. However, those migrants were still pushed at. And then also there were breaches at border crossing points. So that means that it is a very clearly, very explicitly regulated that once a person crosses the external borders, he or she must fulfill the entry or exit. However, if the entry is refused, the authorities must give a written decision where the person finds an explanation why was refused to enter given state, plus in order to provide with a good administration and to remedy, the person should be able to lodge an appeal for its decision. And it was not a case during that crisis. So not only those persons were not given a written decisions, like I said, if they were apprehended close to the Belarus border, they were pushed right away. So they didn't have any option. And if they were apprehended a little bit deeper in the state, they were very often put in those centers for refugees, but also there they were not allowed to apply. And to conclude, as I said, what we were dealing with, it was a clear instrumentalization by Belarus of migration, and it was a Belarus that had the primary responsibility to address the crisis, because, like I said, also Belarus is a party of the 1951 Refugee Convention. However, the fact that the primary responsibility for addressing the crisis was on Belarus party, it does not change the situation that EU member states and Poland, particularly in that case, should actually consider applications from people crossing the border and to allow them to lodge the asylum application, because actually it should be done without prejudice to international humanitarian law and international human rights law. Those actions taken by Polish authorities reflect increasing lawlessness and erosion of the rule of law within Europe. So this is something that Poland, Hungary are very much struggling, and this is just another example of that. However, and it also be a part of my article, there are very small chances that the state will met any kind of accountability for its action, because as my colleague lawyers know, there is no such a thing like a international government or international police. And also on the EU level, the political climate around migration is very particular, let's put it this way. And I think that also on the EU level, those states, meaning Poland and Lithuania, will not face any consequences for their actions. And with that, I will allow myself to finish. And thank you again for given time.
Wonderful. Thank you so much, Dr. Mazar. We did have one question from the audience for you. If they were curious if you could repeat about the Greece and Turkey border. Don't know if you want to touch on that now.
What was the question exactly?
They asked, please repeat about the Greece and Turkey border. Mm-hmm. It was around cut out.
Mm-hmm. Yeah, so I will allow myself to answer these questions now, because I have to teach after this panel. I have to go and conduct my class, but if you allow me to teach. So as you know, the relations between EU and it may be differently between Turkey and Greece are very tense. However, during the migration crisis 2015-2016, member states signed an agreement with Turkey, which actually was a very pragmatic deal, because the deal clearly said, it was an agreement from March 2017, and it clearly stated that every person that is crossing the Greek border in an irregular way will be returned to Turkey, and for that one person, European Union states will accept a refugee coming in a regular way. And of course, Turkey was granted 6 billion euros from the EU in order to prevent people from Turkey coming. So those money were supposedly to be used for education of Syrian, mainly Syrian kids, and with providing them basic conditions. So this was another sign of externalization of the refugee policy by the EU. And what I also want to say is that I mentioned the Turkey-Greek crisis, what happened on the border, Greek-Turkey border, because although this agreement was signed in 2017, and again, for young legal minds, this is a very interesting agreement, because first of all, it is not an agreement between EU and Turkey, but it's between member states and Turkey. And also the form was very controversial, because it was not, it did not went through European Parliament. It was just announced as a press release. So also here, there was a lot of question, what just happened and why did it happen. However, since it was, like I said, it was considered a very pragmatic tool, because a very pragmatic measure, because it prevents people from coming to the Greece. Like people, there was no discussion on the EU level regarding that. Now, what happens is that very often those states, so as you can see, the externalization of migration policy works both ways, because it helps, but also the third countries are having leverage over the EU. So the same way that Belarus used that leverage, the same thing happened with Turkey, because at some point they opened their borders and people started to cross border with Greek, and there was even shooting to those people were shot by the Greek officers. So that is why I mentioned that situation, because like I said at the beginning, the thing that Turkey the thing that Belarus did was not the first time that it happened. And since the EU is externalizing its policies more and more, like I said, it works both ways. So those third countries will have leverage over the EU more and more often. And they will take advantage of that leverage, obviously.
Wonderful. Thank you so much for expanding on that and providing more insight. If you would unshare your screen for the moment, I would like to bring back Mr. Mate and Dr. Koka for some additional questions. I know our faculty advisor, Dr. Reed, has a couple, so I will let him lead us off with questions.
Yes, I'd like to begin by thanking everybody for wonderful presentations. And I noticed there's a kind of the word synergy is overused, but there's a kind of collaborative energy in all of these presentations. They all point to several common denominators. One is simply the nature of human conflict. Human conflict brings out the very worst in human beings, of course. And the one unfortunate consequence of human conflict is warfare, and warfare leads to all the tragic results we've been talking about this morning. The displacement of peoples, the flight of refugees, and the crises we've addressed in Hungary and in northern Syria, in Poland and Belarus. All of these have certain common denominators that arise from human conflict. With that in mind, I have particular questions for each of our presenters, beginning with Zsolt Mate. And Mr. Mate, wonderful presentation. Thank you so much for the archival work you've done on the United States, the American response, the Canadian, the Australian response. I'd like to focus in particular on the American response to the Hungarian crisis, and that was to see a coordinated effort between the United States government, American corporations, and coordination with private sector charitable organizations to address very quickly, to address very responsibly, very humanely, a refugee crisis that arose very suddenly. and result in the displacement, as you point out, of 2% of the population of Hungary. A large, immediate, abrupt displacement that was handled very well. My question to you is, from your study of the archives and the sources, how can we rekindle that to address some of the contemporary crises we're seeing in places like northern Syria, in Turkey, and in the Belarus-Polish frontier? Because we do not see any longer the kind of sustained, coordinated humanitarian response we saw demonstrated so well in 1956. If we see 1956 as a success story, we do not see that success replicated today. That's my question to you, Mr. Maté. My question to Dr. Kocha is that we see again this response to the crisis brought on in northern Syria. We have seen now the displacement of peoples for more than a decade. People have been refugees now for more than 10 years, 10, 12 years. This is no longer simply a situation involving temporary displacement of peoples, but people forced to live large parts of their lives in very temporary quarters. What is the responsibility of the international community to a situation that now is no longer simply a temporary response, but something that is beginning to resemble a long-term crisis? I think there is a very large and unaddressed international responsibility that should be put to international agencies. But I would welcome your insight on that. And finally, to Dr. Mazur, Professor Mazur, we see as you point out, we see the instrumentalization of refugees as a tool, an instrument of war. We're seeing war being redefined very tragically in the modern world as a kind of hybrid war, as you point out. I think there's another word that is not used here, but a kind of total war. We're using all the means of human conflict at our disposal to destabilize other nations. Certainly, that's going on in the Belarus instrumentalization of refugees. So my question to you, Dr. Mazur, is: can we begin to redefine the laws of war to address this? You've done a very fine job of addressing the EU responsibilities, and the Polish, and you very bravely critique the Polish non-response to this situation. But can we begin to redefine the laws of war to capture some of the Lukashenko's regime behavior and hold the Lukashenko regime responsible for some of the actions they've provoked? Those are my questions to each of the three panelists, and I look forward to your responses. Begin with Mr. Maté.
Thank you so much for your comment and for the question. I would say the situation of today is very different than the age of 1956. First of all, for example, the US in the 50s did not have this big illegal immigration on the borders. So today it's a bigger debate on immigration. I read voter letters towards Kennedy and also to Richard Nixon. And there, the amount of criticism of accepting refugees, the xenophobia of the letters, is much smaller. It's less than 5%. I don't know, I haven't seen current letters from voters, but just by reading the comments all around the news sites and the social media, I would say that can be a bigger number. So there's a bigger debate on accepting refugees or not from the society. Also, the American society replied in 56 to accept these refugees, and the government had to oppose. And from the willingness of the government, it's like still available today. For example, Canada with the Syrian refugees had an excellent immigration policy, and that was a very well organized reception as well. And also what they are offering now to the Ukrainian refugees is a very well thought system. I think the US has still the availability with the air transportation and the reception methods, also has the intelligence reports to like find out who's an unwanted person to the US because in 1956 they had the capacity to do that too, seeking out communist secret agents, for example, from the refugees. So I think today all the capacity is available, but the willingness of the government is different, I would say, because the openness of the society is much like not against it generally, but more against it than in 1956. I hope I answered the question.
Did. Thank you.
Thank you.
Dr. Koka, please.
Thank you very much for the question. As you said, the Syrian civil war started on 2011, which has been taken 12 years. Actually, in the beginning, I would like to first talk about the policy of Turkish government. Turkey didn't have any immigration policy towards refugees coming to country. So Turkey saw these people are coming to Turkey for a limited time period, and they will turn back to Syria as soon as possible. And they were thinking that Assad regime will go down soon. So we didn't have, Turkish government didn't have any integration policy at the beginning. They accepted the situation as a temporary situation. But when it's been 12 years, there are babies, like Syrian families are having babies, they are having children. So these people are born in Turkey, they are going to the schools, they are learning Turkish. Their life is going on in Turkey, like it's like their main country. Turkey become their main country. So it's difficult to see them as a temporary situation, and it's difficult to send them back to Syria after even the Syrian civil war ends. Now, Turkey is hosting more than 3.7 million refugees. Also, Jordan is hosting 1.3 million Syrian refugees. And it's really difficult to handle this high number of refugees as an individual country. So Turkish economic situation or the Turkey's economic power is not enough to provide social welfare for the refugees in the country. And there are, besides positive sides, there are also negative sides. The sides of the higher number of refugees in the country. And this has been used by the political parties, especially when we look at the next elections in Turkey. There are far-right parties whose only promise is sending back refugees to the Syria. So at the end, for your question, I can say that international collaboration, international cooperation can be a support for this situation, because every country, every state is taking care of their own benefits. European Union is making a convention with Turkey to send refugees who comes to Greece back to Turkey. So this means they won't have more refugees. Besides that, they will give 6 billion euros to Turkey to support rehabilitation of refugees, to provide social welfare. And this 6 billion euros doesn't directly go to the Turkish government, not only the Turkish government, also to the NGOs operating in Turkey. So every country is taking care of their own interests. This is a problem. If Turkey had the chance, it would do the same, actually, to be honest. So international collaboration, international cooperation can support to find solution to this situation. And also, instead of destabilizing countries, the states can focus on supporting humanitarian aid to the states who have internal problems. Turkey couldn't foresee the result of Syrian civil war because Turkey also supported opposition forces in Syria to down Assad regime. But at the end, Assad regime is still in power, and we are hosting 3.7 million refugees. There are more Syrians in other countries, the European Union, Jordan, other countries hosting, and the result is mostly negative. So international cooperation, international collaboration can support to find solution to this problem. And also the states shouldn't take care of only their interests to support international peace, international security. And I hope I could give an answer to your question. Thank you.
Dr. Mazur, shall we revise the laws of war?
Yeah. So, Professor, you touched upon a very important topic, and let me just, like, from history perspective, the definition of refugee was created in 1951 at the height of the Cold era, and obviously the creators were, as you know, the limitations, the geographic and time limitations imposed there showed that probably none of those persons that created that act could foresee what the future will bring and how often those mass movements will happen. I know that there is a cohort of researchers that claims that the definition from the 1951 convention is enough and it does not need improvement. However, I do believe that it is a time for change. But from a very realistic perspective, and that actually what discussion over Global Compact on Migration and Global Compact on Refugees in 2018 showed, there is no willingness on international level to touch upon that and to have any kind of decent conversation regarding what happens to people that are forced to flee their homes.
Well, I would like to thank each of you. We are now at the clock here. You're in different time zones, but it's 9:44 a.m. And we are scheduled right now to transition to our second panel. So I would like very much to thank each of you. This has been a wonderful, wonderful start to, I think, will be a wonderful, productive day of exploring the crisis, the global crisis of refugees and immigration, and so I'd just like to say thank you. This has been a wonderful start, and I look forward to your published work in the coming months. Thank you.
To echo Dr. Reed, thank you again. We really appreciate all of you for your contribution, for your willingness to participate in our symposium. It's not very often that we get a wide variety of international presenters. So I'm very grateful for all of you for taking time out of your busy days to share your time and work with us. So thank you for that. And with that, you all can turn off your cameras and we will take a 15-minute break, and at 10 a.m. Central Standard Time, we'll move to our second panel. So thank you, everybody.
Thank you.
Thank you.
All right, it is 10 a.m. Central Standard Time, so we'll get started. Sorry, Central Daylight Time. So we'll get started with our second panel here. I'll give some short bios of each of our panelists, and then I will invite our first panelist to turn their camera on and to unmute themselves. So first, we have Lindsay Gracing. She is a staff attorney at the Advocates for Human Rights, working on federal policy advocacy around immigration and other human rights issues. She also provides direct legal counsel, training, and mentoring for attorneys handling T visa applications for non-citizens victims of human trafficking. Lindsay has worked on immigration issues for nearly 10 years, including work in private practice, law school clinic, and in her current role. She's also worked for many years in conflict-affected states, including with the International Organization of Migration, the U.S. Department of State, the International Criminal Tribunal for Rwanda, and other nonprofit organizations. Lindsay has previously served as an adjunct professor of immigration law at the University of St. Thomas School of Law and is a member of the American Immigration Lawyers Association. So we're happy to have her back. In our second panel, our second speaker for this panel, we have Jeff Heidkamp and Rachel Davis-Shear. Jeff is a 3L, current classmate of Taylor and I at the University of St. Thomas School of Law and is a law clerk at Davis and Goldfarb PLLC in Minneapolis, Minnesota. And prior to law school, he had a 20-year career as a public school teacher, local pastor, and national leader in Christian denomination. And Rachel Davis-Shear is an immigration attorney at Davis and Goldfarb PLLC in Minneapolis, Minnesota. She earned her JD at the University of St. Thomas School of Law with highest honors in 2016. She is listed as a Minnesota super lawyer for immigration law in 2021, 2022, and 2023, and is an active member of the American Immigration Lawyers Association. She speaks frequently on immigration law related topics and is an active lifelong member of Beth El Synagogue. So we're happy both of them are joining us today for some St. Thomas alumni and students. And lastly in this panel, we have Carlos Leonardo Santana Bahrain. He currently has a master's degree in human rights and international humanitarian law from the National University of Columbia. He currently works at the NGO Justa Paz as a legal professional in child recruitment prevention and support for vulnerable communities and victims of the armed conflict in Colombia. Carlos previously worked in the Jose Alvera Respo, my apologies if I mispronounced that, Lawyers Collective as an associate, and he has worked as a university professor. Carlos' professional experiences has allowed him to handle situations related to the reparation of victims of serious human rights violations and related issues such as transitional justice, forced appearances, freedom of expression, right to social protest, discrimination, and violence against women, American human rights systems, universal human rights system, police violence, international environmental law, the law of indigenous communities, extrajudicial executions, arbitrary deprivation of liberty, truth commissions, the rights of refugees and migrants, and the like. So very excited for this panel, and we will kick it off with Lindsay Gracing. If you'd like to turn your camera off and unmute yourself. If you have any panels or slides, you're free to share your screen at this time.
Great. Thank you for having me. I'm happy to be presenting again at St. Thomas in a non-professorial capacity, but I'm excited about talking today about how we can craft U.S. immigration policy that welcomes individuals with dignity and upholds our U.S. obligations under the law. So when we're looking at refugee and migrant rights, we have, from a legal framework, international law, federal law, and state systems, all of which play a role in our response. As you can see from the panels today, many other panelists will go into pretty serious depth in terms of our US obligations under international law. But there are several particular treaties and bodies of law that are important when we're conceptualizing our response to migration and our duties under the law. The UN Convention on Refugees and its protocol has been spoken about already today. This really provides the basis for what our definition is of refugees and asylum seekers, and it creates a mandatory obligation among state parties to uphold non-refoulement and basic standards. I'll talk about that a little bit more. The US is also a party to the UN Convention against Torture, and that similarly has a non-refoulement obligation. We're also a party to the Palermo Protocol, which speaks to our obligations to prevent and punish trafficking, as well as protect victims of trafficking. And the US is party to several other human rights conventions, many of which have obligations not to return individuals to serious harm or human rights violations. And this is what's often discussed as complementary protections. These are protections that complement our obligations under the UN Convention Against Torture, as well as the Convention on Refugees. And then we also have the Global Compact on Migration, which is a non-binding kind of aspirational document that the UN created in 2018. And that really provides a helpful framework through which we can kind of think about how we can develop a response that rises to the task of providing protections and welcoming people with dignity. So under these treaties, what are our international obligations? And again, I think several panelists will go through this in more depth, so I'm going to kind of do a brief overview, but non-refoulement is something in both the Refugee Convention protocol and the Convention Against Torture. And it's basically a principle that says no country can return an individual to face persecution or torture. Again, those complementary protections in other human rights treaties say that state parties cannot return an individual to face other human rights abuses. So when we think about whether the UN Convention on Refugees or the Convention Against Torture are relevant for today's kind of challenges in terms of refugees and migration, complementary protections might be a great way to think about how we can provide protections for individuals for things like climate displacement, or people who are displaced by armed conflict or economic insecurity, but which don't fit nicely within existing refugee protection frameworks. The UNHCR handbook with guidelines on application procedures for the Refugee Convention also provides some positive obligations for state parties to implement the convention and its protocol. And this includes a meaningful opportunity to apply for protection under the Refugee Convention. It also states that application process should be trauma-informed with officers who have specialized training. Individuals who are applying must have access to interpretation as well as an opportunity to appeal a negative decision. And it provides that there should be special protections for children as well as people with mental health needs. Under the Universal Declaration for Human Rights, as well as the ICCPR, and comments to the Refugee Convention, family unity is a significant obligation of states and a principle in international law that states agree is an important kind of underpinning of how we develop our response. So family separation policies are not in line with this basic principle. Additionally, many of the treaties include an understanding that they must be implemented non-discriminatorily, as well as by providing equality. And so any kind of response to our migration policy that creates arbitrary distinctions between people based on their race or their nationality can put us in violation of our international obligations. And then finally, under the Palermo Protocol on Trafficking, we have an obligation to prevent trafficking as well as protect victims of trafficking. And as we'll talk about with the Global Compact on Migration, the international community has agreed that having unsafe and unfair immigration processes can lead to human smuggling and trafficking, as well as exploitation of individuals. So crafting an immigration policy that creates arbitrary barriers or makes it more difficult for people to seek safety that they're entitled to under international and domestic law can actually also violate our obligations under the Palermo Protocol by failing to prevent and punish trafficking. So the US, as I mentioned, has ratified the protocol to the Refugee Convention, the Convention Against Torture, and other human rights treaties. We've incorporated this into our US domestic law as both the Refugee Act of 1980, as well as provisions of the Immigration and Nationality Act, or the INA. The Trafficking Victims Protection Act and its reauthorizations in US law incorporates our obligations under the Palermo Protocol, as well as obligations related to protecting children who are displaced. And then, as we all know, as lawyers, our regulatory guidance provides rules on how that will be implemented. So while our US legislation generally meets our international obligations, the way that that's implemented and the gaps in our legislation has resulted in policy that can result in violations of international law. This is particularly true as we're seeing an increased politicization of immigration, as well as kind of a fear-mongering that there is a crisis at the border or that refugees are coming in waves and that we don't have the ability to respond. So kind of those gaps in our legislation are creating opportunities for US policy to be in violation of international law. And the US courts have really played a huge role in the past at least 5 years in making sure that any violative policies have been struck down, although that takes time, and as a result, people's lives have been impacted by that. So when we're thinking about the theme of this symposium, is this a crisis of migration? Is it a crisis of people, or is it a crisis of our systems kind of failing to meet the challenge? I think it's helpful for us to conceptualize what actually is the landscape, right? We're talking about a crisis of movement. We've seen the largest number of people displaced ever in our history, but what actually are those numbers? So 103 million people worldwide are estimated to be displaced according to the UNHCR. 4.9 of those people are asylum seekers, and 32 million of them are refugees. But the US takes only 1% of this population, according to the Department of State. In 2001, we saw historic levels where the US took just 12,500 individuals as refugees, while our congressional cap puts this at 125 that we can allowably take annually. We're moving back up to that under the new administration, but again, this is just about 1% of the world's refugees, leaving kind of everyone else to do their part. And since 1975, the US has only actually resettled just 3 million people in total. So when we're thinking about a crisis or a rush at the border, this is a relatively small number. In 2022, the US received 756,000 asylum applications, and that's adding to this backlog of 1.6 million pending asylum applications. But I think when we're thinking about this number, it's important to think whether that number represents a crisis and a large number of people who are, burdening our system, or whether our system is ineffective in responding. And when we're looking at numbers at the border, CBP recently reported that they saw 200,000 apprehensions per month in 2022, and that this is kind of cause for us to change our policies, abandon our obligations under international law. But when we look at it, these are actually similar numbers to what we saw in 2000, and it is up from 60,000 in 2019, but 200,000 can also represent kind of people who are counted multiple times. We know that we still have kind of holdover from a number of Trump administration policies that have not either fully dissipated under the Biden administration, or which kind of still have residual impacts, such as the Migrant Protection Protocol or Remain in Mexico policy, as well as Title 42. So individuals who are attempting to enter the United States are unable to do so, and then continue to try because they need to seek protection in the US. Those people might be recounted as this 200,000 number. So we don't have a realistic understanding of how many people are actually trying to seek protection. So I think it's important for us to remember too that we have systems to respond. And while there are large numbers of people on the move, we also are in a completely different place in terms of our capacity as a world to respond to issues. And that's really what the international community came together in 2018 when it adopted the Global Compact on Safe, Orderly, and Predictable Migration, kind of an agreement that there was a need to change how we responded, and that if we work together as a world community and really utilize the many resources that we have available, we can not only develop positive, helpful policies that really meet that humanitarian need, but that safe, orderly, predictable migration actually benefits many of us, right? We need people to be able to move for business purposes. It can be economically viable. States are made safer and more stable when we have kind of predictable, orderly processes. And of course, people naturally have families, and migration has been part of the human history since the beginning. So developing policies that kind of are responsive to that is what the goal is, right? And so the Global Compact is non-binding, but it recognizes kind of this interplay of these various needs. And it also provided that we should have a unity of purpose. So I find this quote to be from the compact to be really helpful in kind of thinking about what we should want our US policy to look like. Migration should never be an act of desperation, but when it is, we should cooperate to respond to the needs of migrants and address their respective challenges. And the compact notes that not only do we need to have safe, orderly, and predictable migration pathways so that people aren't necessarily forced to move out of desperation, but if they are, that we welcome them and ensure that they have access to dignity in the process. Yet the US system is falling short of this. So the Global Compact says our policies should be safe, orderly, and predictable. The US does none of these things at the moment. So our migration is not safe. According to IOM, the International Organization for Migration, there have been 728 deaths at the US-Mexico border in 2021. And this is very much a reflection of the fact that by failing to provide a safe, orderly pathway that people can utilize to either apply for a visa in advance and have that be granted through a kind of fair, orderly process, or by having sufficient infrastructure in place to process asylum applications fairly. We have a number of people who are now having to seek other forms of entry or are falling victim to gangs and cartels that are taking advantage of this instability that we're creating at the border. Even if a person gets into the United States, however, we also have an unsafe immigration system. In 2020, ICE reported 21 deaths of people in ICE custody, and that doesn't account for individuals who were severely injured or suffered other kinds of harms. Our process is also not orderly, right? We lack viable routes that kind of respond to the realities of how people are moving, business needs, family reunification processes. And by having kind of this arcane system that fails to provide those routes, we aren't providing an orderly opportunity for people to move, which then creates this instability and this migration crisis that people are discussing. We're also investing in expulsion over that processing system and over those orderly methods for people to move. And so while we can see in our policy that people are arguing or fear-mongering that we don't have the ability to create orderly systems, if we look at how much money we're spending and how many resources we're putting towards expulsion and border patrol or on detaining individuals, we just simply need to shift those resources around to be able to meet those challenges. Again, our system is not predictable. The fact that policies change every 4 to 8 years with a new president, and possibly even more often as we have a policy introduced that's then litigated, struck down by a court, changed, that doesn't provide advocates or individuals who are seeking to migrate a predictable way to kind of know how to apply for safety or know how to apply for migration, and that creates more instability and more crisis of people who are simply just trying to rush in to move. We also then risk refoulement, as we talked about. There's risk of return to serious harms and human rights abuses. Our immigration processes routinely violate due process. And like I said, by creating these bars to safe, orderly, fair migration, we actually are increasing the vulnerabilities of individuals to human trafficking. So is all lost, and is this a crisis that we cannot solve? Several kind of modern examples prove that the US does have capacity to respond if we have the willingness to do so. So in 2001, the US launched Operation Allies Welcome, aimed at resettling and accepting Afghans who have been displaced by the US withdrawal from Afghanistan. This program has significant issues, and we could have an entire symposium about the US withdrawal from Afghanistan and our response there too. But it is a positive example of the fact that when the US wants to, and if it thinks creatively about infrastructure and processing mechanisms, we can respond to a large influx or a large number of displaced individuals that need safety. We were able to this program worked because it utilized the fact that local communities wanted to welcome individuals. Overwhelmingly, people in the United States agree that we should be upholding the Refugee Convention and welcoming asylum seekers. But when we have infrastructure that places the burdens only on the border or only on certain processing centers, then that means that we don't have the ability to fairly and predictably and orderly process individuals, whereas Operations Allies Welcome moved individuals based on where we had capacity to process them. And that really has resulted in some improvements. Again, many issues with this process. Uniting for Ukraine is almost an even better example, possibly because the US had greater political interest in welcoming people displaced from Europe rather than from other parts of the world. Uniting for Ukraine allowed individuals to come on parole for a short period of time, and then once they're here, they can access other forms of permanent status if that's what they need. And again, this really took advantage of the fact that US communities really support welcoming individuals by allowing certain people to sponsor someone from Ukraine, and that helped kind of ease the processing again. The Biden administration has sought to kind of replicate this with parole programs for Cubans, Haitians, Nicaraguans, and Venezuelans. And then really excitingly in 2023, it rolled out a program called Refugee Welcome Corps. And this is kind of to rethink the way that we process refugees. And so because the US only takes about 1% of refugees, our refugee processing mechanism is just hugely slow. And we have an inability to place people in communities, even if communities are overwhelmingly saying that they want refugees. And so the Refugee Welcome Corps allows private individuals, groups of 5 or more people to say that they would like to serve the role of a refugee resettlement organization, essentially welcoming an individual and having at least basic needs met when the person comes through the refugee resettlement program. Again, with all of the same security vetting that we already have for our refugee program, but this is kind of a unique way to rethink how we're processing individuals and putting it less on the government solely and more on a community that wants to accept individuals. We also can see how we have the ability to respond if we change the way that we're utilizing our resources, right? So in 2021, DHS piloted a program called Alternatives to Detention Case Management Pilot Program. And in that program, DHS started using case management instead of detention for people who were in immigration proceedings. 99% of the people who participated in this program complied with ICE check-ins and appeared for court hearings. And the cost of that program was $38 per family per day versus $319 to detain a family under detention programs. So again, we have these resources. Look at DHS's budget, which in the last round was a request for $103.2 billion. If you think about that and that and the fact that it costs us $38 per day to use an alternative case management system, we have this money that we could be using to fairly process individuals. We're just thinking about it incorrectly, right? And just to kind of put that in more perspective, since 1993, the annual budget of, this was to say the CBP was $4.9 billion for Border Patrol. And that increased to for the whole DHS was 4.9 billion, and Border Patrol increased to 363 million that we're just kind of using just for enforcement at our border. So if we kind of rethink our use of funds, we'd be able to do that. And again, there are state and local examples of how communities want to do this, which can be a great way for us to be able to respond. So 70% of voters in a survey agree that we should have a refugee program. 50% think that we should ensure asylum. So even though we're hearing that communities overwhelmingly do not want to welcome asylum seekers, that's not the reality of how people are reporting in bipartisan surveys. We also saw that there was this kind of political move to send individuals on flights and buses from southern border states, but then the response of welcoming those communities to the places where they were sent shows that we actually may just need to kind of shift how our processing is done so that border communities don't feel that they're overwhelmed, and that communities who want to welcome and that have capacity to do so can. We saw that New York, DC, Chicago, Denver, Martha's Vineyard all set up adequate processing centers, housing, et cetera, for individuals that they received from these southern states. San Diego has had a really great shelter model since 2018, which has served 120,000 people. Again, kind of utilizing local resources to process where the government maybe isn't. And Minnesota, as we know, is kind of the North Star state of welcome. And so as part of Operations Allies Welcome, we received a number of Afghans in Minnesota, and the state of Minnesota moved to make a coordinated response that ensured that individuals who were resettled here had access to counsel, basic needs assessment, social workers, and communities that would be able to welcome them and really ensure that they were adequately incorporated into our communities and had their needs met. We've also seen this with our refugee processing in Minnesota, as well as the fact that many county and local governments have stepped in to provide funding to ensure counsel for people who are in immigration court proceedings. So while the US government fails to do so, state and local communities are really stepping in because there is this understanding that we have this shared value that wants to welcome and that really can. So I think in closing, I'd just like to have us think throughout this symposium about what is the crisis? Is it a crisis? Is the crisis people, or is it our response to movement of people or our systems? People are moving more than in the past, but we also have significantly greater capacity to frame responses. So with that, I will move on to our next panel. Thank you.
Wonderful. Thank you so much for that wonderful presentation. I know I have a couple questions, but we will move on. Yeah, Rachel, we'll go with you. Yes, and Jeff, there we go. All right, you two can introduce yourselves. If you have any slides, you can share your screen at this time, and I'll hand it over to you two.
Thanks, Lindsay. That was a really fantastic presentation and a really good backdrop to our topic of U.S. legal and moral obligations at the southern border, specifically with respect to the Central American asylum seekers. And basically, Lindsay's presentation gives just a great background and context. We're doing kind of a deep dive into our obligations under U.S. law, how we're currently failing to uphold those obligations with respect to asylum. And then at the end, if we have time, we'll offer recommendations of how the United States can restore a more legal and more moral asylum system, especially with respect to the so-called border crisis. And I think Lindsay introduced this perfectly. Jeff and I share the view that it really isn't necessarily a true crisis, or maybe more one of our own making or political framing. Just to briefly introduce myself, my name is Rachel Davis-Sharp. I'm a senior attorney at Davis & Goldfarb, a full-service immigration firm right across the street from the law school. And I primarily practice business immigration, but I've always maintained a pretty substantial asylum practice in addition to my regular work. And Jeff is one of our fantastic paralegals who thankfully will soon be an attorney with our firm. And he and I work really closely together on all kinds of immigration matters, ranging from, green cards for, actual rocket scientists, some of the most important people in the world, and I'd say at our country, to Afghan asylum seekers or asylum seekers from all over the world. Like Jeff, I have a personal connection to this area of the law. I'm Jewish, and like thousands of other Eastern European Jews, my family fled Russia in the early 1900s because of the pogroms where thousands of Jews were being targeted, attacked, and killed, including some of my own family who was murdered in that way. Because I think my grandma's tuned in from the beauty shop this morning, I'll tell a quick family story. My grandma's grandma, so my great grandparents, escaped Russia in 1914, and it took them 7 years to cross Europe. They were eventually able to leave Liverpool and arrived in Ellis Island 7 years later in 1921. And a lot of their other family members, they actually went straight to Canada, where they lived for a little bit. And then they eventually crossed the northern border illegally into the United States, where they ultimately settled here in Minnesota, which is the reason I'm here speaking in front of you today. The conversation we're having today is about the southern border in a dramatically different situation than the one that my family experienced just over a century ago. And our presentation today and the article we're writing was initially inspired by a paper I first wrote in law school back in 2016 when I was a student here at St. Thomas. And at the time, I was a student attorney at the immigration clinic working under Virgil Levy, who's speaking later this afternoon. And I almost exclusively represented young asylum seekers from the Northern Triangle countries of El Salvador, Honduras, and Guatemala. My clients were ages about 8 to 15 or so. And my clients, their families, and thousands like them make up the so-called border crisis that you no doubt hear so much about on the news and political debates, maybe in your Facebook newsfeed. And there's a lot of misinformation out there, but basically, in short, what is the border crisis? Since 2014, the United States has seen a dramatic shift in the kinds of migrants arriving at the southern border. So for decades, single Mexican men made up the majority of those attempting to cross the southern border. But for almost a decade now, we've seen a growing number of women, families, and unaccompanied minors from the Northern Triangle countries. And we're seeing these unprecedented numbers of migrants from this region because the Northern Triangle suffers from pervasive and absolutely brutal gang violence, government corruption, frequent extortion, and some of the highest rates of poverty and violent crime in the world. So basically, the two main rival gangs control vast territory in these countries, and they just kidnap, rape, murder thousands of victims with basically absolute impunity. And it's been this way for many years now. And outside of war zones, like some of those we heard about this morning, and some other countries, these are the most dangerous and deadly countries in the world. Jeff and I are especially interested in this particular subset of asylum seekers from Central America because our legal system has bent over backwards to deny them relief in the United States under our current legal framework. So when I first wrote that initial paper when I was in law school, Obama was president. And full disclosure, I am a very big Obama supporter. But back then, and even to this day, I've been extremely critical of Obama's policies in response to this humanitarian crisis on the southern border. Then came Trump. And of course, as most of us know, he completely shifted the conversation on immigration and the southern border. And as an immigration attorney, I honestly just don't have words to describe how horrible the Trump years were in immigration law on all fronts, from employment-based immigration to family-based and certainly humanitarian-based areas of our immigration laws. And I'd argue that no group was treated as horribly under Trump's immigration laws as Central American asylum seekers on the southern border. So you can probably think back to some of the things we were hearing a lot about at the time: family separation, children in cages, just really, really morally repulsive things. While Biden immediately reversed a lot of Trump's most harmful policies in this area, some of his most recent policies are concerning and ones that we criticize in our paper. To be clear, Jeff and I are not arguing that we should open up the borders or let in all immigrants, or even that we should grant asylum to anyone with a sad story or escaping poverty or dangerous conditions. We make two basic arguments rooted in law. One, asylum law is good and fundamentally American, and Jeff is going to talk about some of the background to our moral and legal obligations in just a few moments. And two, asylum law is being misapplied to Central American asylum seekers to deny them humanitarian relief based on political reasons rather than sound legal reasoning. So with that, I'll turn it over to Jeff.
Sorry, okay. Thanks, Rachel. So we'll talk a bit about the legal and moral obligations that the United States has at the border. Our legal obligations begin in the Constitution. So this is a quote from the Federalist Papers, the essays written in the late 18th century to defend the new Constitution. And here James Madison observes the chaos that had ensued under the Articles of Confederation when each state was allowed to make its own border and immigration law. And he said that the new Constitution would locate immigration law in one central place. So here in the first article, the eighth section of the Constitution vests the power to make immigration law in Congress. And it's really notable that this isn't an implied power like derived from the Commerce Clause, as so many congressional powers are, but this is directly vested by the Constitution in Congress. So in 1980, we've already talked about this, Congress passed a law called the Refugee Act, which said that any alien who's physically present in the United States, irrespective of such an alien status, may apply for asylum in accordance with this section. This is fairly clear, and we're not going to be able to get into details about the administrative law issues that are raised, but I want to emphasize that this is a law passed by Congress, which is higher in power and authority than regulations. Regulations, whether passed by DHS or ICE or the Department of Justice, are to flow from congressionally passed laws. And any regulation that violates this law is illegal. Congress passed this law, and here we start to get into the moral reasons. According to Ted Kennedy, who was the sponsor of the law, and there's an enormous amount of other similar quotes in the congressional record, specifically based on the United States' national commitment to human rights and to humanitarian concerns, not at that time reflected in the immigration laws. It's already been said, the Refugee Act of 1980 flowed from the 1951 Convention on Refugees, the moral center of which is non-refoulement, stating that you can't send somebody back to a country that they'll be persecuted in if they've claimed asylum in your country. To begin to understand the moral context of the 1951 Convention on which our 1980 Refugee Act was based. And just one brief aside, for those who are skeptical about international law, I just want to repeat what Lindsay already said, which is that this is international law encoded by Congress. So this is not merely international law, this is US federal law. The context of the 1951 UN Agreement on Refugees was that it was written as the world was discovering and reacting to the Holocaust. Many Jewish people had attempted to escape Germany and been denied entries in countries like the United States, including the family of Rudy Boschwitz, a former Republican senator from Minnesota, who told his own family story on the floor of the Senate during the 1980 debate. The 1951 law was a direct response to the reality that Jewish people who were running from Hitler were turned away at border after border before the Holocaust. When asylum is referred to as a loophole or a workaround, this context should be borne in mind. When a senator like Lindsey Graham suggests, as he recently did, that the right to asylum should be revoked, that needs to be understood as a step backwards in the international commitment to fight genocide. So the asylum rule, stated simply in US law, is this: once a person who's within the United States territory, if that person requests asylum, they must be given a fair hearing. And if they meet the definition of refugee, they're to be considered for asylum in the United States. The asylum rule then is part of the moral purpose of the government of the United States. One of the most enduring symbols of the United States is the Statue of Liberty, with the poem by Emma Lazarus proclaiming welcome to the suffering yearning to breathe free. The promise that a great country could be built by those who were forced to flee other lands. Okay, for the sake of time, I'll skip over moral reasoning by noted secular scholar Michael Walzer, reasoning from the U.S. Council of Rabbis, the U.S. Council of Catholic Bishops, other logic from the founding documents, and begin to think about the roots of the asylum rule in the Bible itself. Two stories are important. First, the Exodus. The story of the Exodus in the Bible tells about the people of Israel escaping slavery in the land of Egypt. As they moved toward their future homeland, they were given this command. The command was, do not look down on or oppress the foreigner in your midst. Now, if you imagine for a moment, who would want to escape into the wilderness with a huge company of runaway slaves? Most likely those who were struggling or in the lower economic rungs of society. And it is precisely these ethnic outsiders that Moses commands the people of Israel to accept and treat as their sisters and brothers. Jesus later tells the story of the Good Samaritan to a lawyer who had asked for further explanation of the command, love your neighbor as yourself, which is a very lawyerly thing to ask. The story tells of a man who's mugged and left for dead on a dangerous road. Two high-ranking religious officials walk by, but refuse to help. Then an ethnic outsider, a Samaritan, stops to help the man, brings him to a hotel, and pays for his care. Jesus says that it is this one, the Samaritan, who showed what it means to love neighbor. From these two stories, we can derive this ethical rule. True love of God and neighbor means costly, generous love to those who have need and those who are near. For the United States, this means Central American asylum seekers on our borders. We may find it easier to accept Ukrainians or Afghans for various domestic or geopolitical reasons, but the asylum rule, which is rooted in US law, international law, US values, international values, and even the Bible, tells us that if we do not show neighbor love to those who are near us and in need, we fall short. I tell these stories to demonstrate that asylum law is not some flashy new social justice program. It is an outgrowth of a deeply human instinct toward hospitality and love of neighbor. It is rooted in Middle Eastern practices of hospitality and the religious commands to love the stranger even at cost. The asylum rule is one of the most profound manifestations of these profound ideas. So how have recent administrations violated US legal and ethical obligations at the border? First, they've attempted to prevent migrants from getting a fair asylum hearing before an immigration judge. Again, we don't have time to go into the most recent regulations at the border, except to say that there's an illegal requirement for many migrants that if they want to claim asylum, they have to use an app on their phone in order to schedule their asylum claim, which I don't know about you, but scheduling an asylum claim seems to go counter to the idea of what it is. This has resulted in tragic results. A month ago, a 4-month-old baby in need of emergency surgery died because their parents were unable to secure an appointment through an app. Now, it may be the case, in fact, it is the case, that the United States cannot save every sick baby in the world. But this baby was protected under US law. This baby was protected under US obligations, and we failed to protect it. Furthermore, the US has failed to live up to the asylum rule by failing to give a fair hearing to those who do seek asylum, and instead they've stacked the deck, we've stacked the deck against unwanted groups, the ethnic outsider of our time, and Rachel will go into detail about how this has occurred.
Thanks, Jeff. So I'm about to kind of boil down asylum law into just a few minutes because we're aware we have a limited amount of time. If anybody has any questions, I'm happy to answer questions during the Q&A, and I would encourage you to read our article that really does a deep dive and gets really technical on the specific legal mechanisms. So basically, asylum law boils down to 3 components that stem directly from the Refugee Act of 1980 that Jeff just discussed and Lizzie discussed earlier. 1, the applicant must be unable or unwilling to return to their home country. 2, the reason must be because they suffered past persecution or they have a well-founded fear of future persecution. And 3, there must be a nexus or connection between that persecution or fear of persecution and one of the 5 protected grounds: race, religion, nationality, membership in a particular social group, or political opinion. So I'm going to zero in a little bit on the particular social group, one of those 5 grounds, because that's the one that most Central American asylum claims are based on. So as an attorney for an asylum applicant, especially one from Central America, one of your main jobs is to formulate a viable particular social group. or most attorneys or most immigration attorneys call it PSG. So most Central American asylum cases rely on that PSG prong, and usually the PSG is related to gender or resistance to gangs, or sometimes some combination of those things. And the vast majority of these arguments are unsuccessful. And that's largely because over the last 15 years, the definition of PSG has been restricted in a way that seems primarily targeted at limiting Central American and Mexican asylum claims. So basically, again, to boil down lots of asylum law in a short period of time, essentially for decades, the term PSG was defined very broadly in a way that was pretty compatible and supportive of these types of claims. So other examples would be women from specific tribes in Africa that were opposed to female genital mutilation, for example. And there's a lot of factual similarities that one would think would point to, be supportive of these types of claims, especially kind of gender-based claims and opposition to gangs, which is another non-governmental group. But in 2008, in what seemed to be a direct response to the increase in Central American asylum seekers with gang-related claims, the BIA, the Board of Immigration Appeals, which is the appellate court in immigration law, it's part of the Justice Department. The BIA issued 2 decisions rejecting PSG based on resistance to gangs. And these cases are really notable, not only because they just reject these PSGs, but also because for the very first time out of nowhere, after decades of well-established law, the court added 2 new requirements to meet the PSG test. And we won't get into the details there because they're really, really complicated and confusing and circular. To be honest, they just make no sense. But this new law made it extremely difficult to win a Central American asylum case. There are a ton of issues with this new test, and I don't really have time to get into them right now. But instead of revisiting them and looking to see, like courts often do, did we get this right? Instead, the BIA has doubled down on that new problematic rule 2 more times in 2014 in similar cases that basically just reject PSGs or a basis for asylum for Central American asylum seekers who are seeking asylum based on different types of opposition to gang recruitment or membership or things like that. These decisions are just very, very inconsistent with longstanding asylum law, and they're including comparable cases like ones that I just mentioned, involving opposition to similar groups or practices from other parts of the world, including ones that are maybe more politically convenient or maybe with not quite as large of numbers of migrants from those areas. So to summarize the legal section that I've just discussed up until now, basically all the case law for Central American asylum seekers has been bad since those decisions in 2008. But then in 2014, there was finally some good case law. And in the matter of ARCG, the BIA, so that appellate court, recognized that married women in Guatemala who are unable to leave their relationship can constitute a viable PSG that forms the basis of an asylum claim. So this offered a glimmer of hope for some asylum applicants with gender-based claims, and it did help. So asylum grant rates did increase during this period, in part because of the extremely high rates of gender-based violence in this particular region of the world. But then came Donald Trump. And in an effort to limit asylum eligibility, then Attorney Jeff Sessions overruled ARCG, the good case that I just discussed, and asylum grant rates just plummeted. This case, matter of AB, is just horrible for Central American asylum cases, not only because it rejected the PSG that I just discussed based on basically domestic violence, but also because it made it almost impossible to win asylum if you're fleeing non-governmental persecutors, like the brutal gangs that control most of or much of Central America. So this case is really just one of the worst cases in asylum law history, in my opinion. And it's really just one of those like morally repulsive cases. Thankfully, one of Biden's first immigration actions as president was to overturn AB and restore ARCG. So Jeff and I, and if you're interested in this kind of analysis of the law, again, I would encourage you to read our paper because we really get specific on the legal details that we don't really have time to go into great detail on here today. So Jeff and I aren't just here to complain about the current state of affairs. Our article does discuss specific recommendations that we can take to restore a more legal, ethical, and consistent system for asylum. So let me preface this by saying Jeff and I are well aware that none of these recommendations are at all likely to happen, or they're basically impossible to happen under the current state of, politics in our country, especially since Trump has really shifted the conversation so far right, not just on immigration, but especially the border crisis. First, we offer several recommendations for different mechanisms to essentially overturn the bad PSG case law that I just discussed. And there are several different ways we can make it clear that gender-based claims and claims related to opposition to gang recruitment do constitute viable PSGs. So this could be done through a lot of different, several different mechanisms that we'll discuss in detail in our paper. But they include ones from the executive branch, like executive action, or even better through new regulations, or attorney general certification, or through the federal appellate courts. A second option, which we know is even more unlikely, but one that Congress has taken in the past, and Lindsay just discussed some kind of similar areas when Congress has the political will to do it, is that Congress could take direct legislative action to those fleeing the Northern Triangle countries. Now back on planet Earth, I'll turn it back over to Jeff.
Yeah. So why do these actions seem so unlikely in our current political climate? Rachel and I laughed actually at the idea that Congress would have the courage to pass some of these laws. First, it is a cheap and easy political strategy to attack immigrants. It's been used for the entire history of the United States, particularly asylees, because they're not allowed to vote in US elections. Furthermore, politicians are tempted to see asylum law simply as a way of fulfilling US geopolitical or domestic political interests, instead of seeing it as a matter of legal and moral obligation. And in particular, Northern Triangle asylum seekers generally do not fit US geopolitical or domestic political interests. An asylum rule, you can see a long history of us avoiding these people. An asylum rule makes promises that are not easy to keep. The generosity of such a rule may be taken advantage of. Moral courage is easier to proclaim than administrate. The organizational requirements of such a rule are difficult to keep. Countries that have made an asylum rule will want to give up on it. But when a country gives up on it, it gives up on human beings to whom we have an obligation. This is my wife when she was about 5 years old in a refugee camp in Hong Kong after escaping Vietnam with her parents and spending nearly a month at sea. She's holding her brother who was born in the refugee camp. Because of the Refugee Act of 1980, because the US Congress chose to abide by its legal and moral obligations to those escaping the Vietnam War, she came to the United States. Today, we have a daughter at the University of Minnesota, another at St. Paul Academy, and family all across the United States, productive citizens who are proud to be in this country. This is what happens when the United States has the courage to fulfill its obligations. And we'll end there. Thanks so much for the opportunity to share.
Thank you so much, both of you, for sharing your personal stories as well as informing us a great deal about your work and the obligations. We will move on to our third and final panelist for this round. If Jeff and Rachel, if you'd like to stop sharing your screen and turn your cameras off. And Carlos, if you would like to share your screen, any slides. Otherwise, you can start when you're ready.
Thank you very much for allowing me to be here with all of you. It is really an honor for me to be part of this symposium. My presentation is related to what I have called first-class migrants and refugees, because today one can observe an increasing intolerance and xenophobia against specific groups of migrants and refugees. However, an issue that is not usually discussed in the same way is the discriminatory nature with which states tend to act in relation to migrants and refugees who are under their jurisdiction. We could think about the way in which migration policies of European countries have been completely different regarding the refugees from the war between Russia and Ukraine, compared to the treatment against refugees or migrants that come from Africa or the Middle East, or the discrimination suffered by Latin American migrants that are trying to reach the United States. To exemplify this, I would like to show you a very short video which allows us to observe how some states adopted privileged measures in relation to a specific group of migrants and refugees, so that with this context, I can later address the next point the next point of my presentation regarding the concept of discrimination and the obligations of states in international human rights law.
Unfortunately, we are unable to hear it. We might have to pass it.
Okay, there is no problem. It's just a short video that shows how the policies of the European Eastern countries and some of the Western countries like the United States have been privileging some of the refugees from Ukraine and not from, for example, Syria or Afghanistan, and they use arguments like these are not the kind of refugees that we are used to. You know, these Ukrainian refugees are special because they are just like us. They are more intelligent. They are more capable of integrate to our own culture. And it's a shame that I cannot share with you this video, but basically, by choosing to privilege certain types of migrants and refugees on top of others, the states are in principle against the provisions of the international law of human rights. But before being able to speak about the international obligations of the states in relation to this topic, it is necessary to point out the concept of discrimination and specify its content in order to clearly establish the framework in which we are going to embark. In this sense, the United Nations Committee on Human Rights has defined discrimination in its general comment 18 as any distinction, exclusion, restriction, or preference, which is based on any grounds such as race, color, sex, language, religion, political, or other opinion, or other status, and which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise by all persons on an equal footing of all rights and freedom. According to this definition established by the United Nations Committee on Human Rights, the discrimination presents three elements to take into account. First, discrimination does not entail the performance of a single specific practice, but can manifest itself through distinctions, exclusions, restrictions, or preference, like is the topic of my presentation. The factors or characteristics by which a person or a group of persons may suffer discriminatory acts is not exhaustive, therefore it is not limited to certain factors that may be prescribed by law or international treaties. And third, discrimination has as its main characteristic the total or partial denial of the human rights of the person or community that suffers from state acts. In relation to the first element, given that discrimination has different ways of manifesting itself, we can find two categories of discrimination: direct and indirect discrimination. Direct discrimination, as you all know, is that which is fundamentally based on the use of some factor or category of discrimination for the differentiation in the treatment of the individual. On the other hand, indirect discrimination is one that, despite its apparent neutrality, since no distinctions are made based on any specific factor, generates discriminatory effects on a person or a specific social group, like is the case of many policies or measures adopted primarily by Western states, such as restrictive employment legislation or language requirements, or the use of an app of the phone, like Jeff said earlier. Regarding the second element, since it has been understood that discrimination is not limited to specific factors, it is important to take into account that new factors may arise based on which a person may become the object of discrimination, or that these categories mutate and change depending on the specific society or historical moment in which we find ourselves. In this sense, it is important that we also analyze the way in which these categories can interact with each other and the transversal effects that they can cause in people. For example, a person may suffer discrimination due to factors such as sex and race, which generates discrimination that is different from what a person who is only framed within one of these categories could face. It is for this reason that the concept of intersectionality becomes fundamental when studying this phenomena related to discrimination in individuals. Some of the most representative works in this regard are those produced by Kimberly Crenshaw and Patricia Collins, who showed how Afro-American women used to face situations of discrimination based on their sex, race, and social condition, for which reason the claims made by the feminist movements promoted by white women did not attend to their particular needs. In this way, intersectionality allows us to understand not only the differentiated effects of different types of social inequalities present today, but also show us how power relations in different social structures are transversal and can affect people in a differentiated way. Therefore, the policies and actions taken by the states can affect the migrants and refugees, not only by this condition, but also has differentiated effects on them, causing a deeper human rights violation. And finally, the third element described is the one that allows us to establish whether we are indeed facing the presence of an act of discrimination. Since not all distinctions or treatment preferences based on some factors such as race or sex can reach be considered discrimination. These are cases in which said different treatment occurs in order to amend deep historical inequalities or to alleviate a situation of vulnerability in which people find themselves, among other reasons. In fact, the European Court of Human Rights has stated that, I quote, "A difference in treatment is only discriminatory when it has no objective and reasonable justification." So distinctions based on de facto inequalities may be established, and such distinction constitute an instrument for the protection of those who should be protected, considering the situation of greater or lesser weakness or helplessness. For example, the fact that minors who are detained in a prison may not be imprisoned together with adults who are also detained is an inequality permitted by law. Or another example of these inequalities is the limitation to the exercise of specific political rights owing to nationality or citizenship. So, having established the main elements of the concept of discrimination, we must point out that this has been regulated in the international human rights law in what is known as the principle of equality and non-discrimination. And this principle permeates every act of the powers of the state in all their manifestations related to respecting and ensuring human rights. Indeed, this principle may be considered peremptory under general international law inasmuch as it applies to all states, whether or not they are party to a specific international treaty, and gives rise to effects with regard to third parties, including individuals. This implies that the state, both internationally and in its domestic legal system, and by means of the acts of any of its power or of third parties who act under its tolerance or negligence, cannot behave in a way that is contrary to the principle of equality and non-discrimination, to the detriment of a determined group of persons. Accordingly, the Inter-American Court of Human Rights considers that this principle of equality before the law, equal protection, and non-discrimination belongs to jus cogens, because the whole legal structure of national and international public order rests on it, and it is a fundamental principle that permeates all laws. Nowadays, no legal act that is in conflict with this fundamental principle is acceptable, and discriminatory treatment of any person owing to gender, race, color, language, religion, nationality, or any other status is acceptable. So this principle forms part of general international law. Consequently, states have the obligation to combat discriminatory practices and not to introduce discriminatory regulations into their laws. And this brings us to talk about the general obligations of the states under the international human rights laws, specifically the obligation to respect and guarantee human rights. The obligation of respect rights and freedoms is of a negative nature. It is the duty of the state to refrain from any type of action that violates or impairs any of the human rights. And the second obligation of states, it is to guarantee the free and full exercise of the rights to all persons subject to its jurisdiction. So these obligations imply the duty of the state parties to organize their entire governmental apparatus and, in general, all the structures through which the exercise of public powers is manifested in such a way that they can legally ensure the free and full exercise of human rights. And it is important to point out that this obligation is not exhausted with the existence of a normative order aimed at making possible the fulfillment of these obligations, but entails the need for governmental conduct that ensures the existence of an effective guarantee of the free and full exercise of human rights. So in this sense, when we jointly analyze these general obligations to respect and guarantee human rights with the principle of equality and non-discriminations, we can determine various consequences and effects that are defined in specific obligations for the states in relation to immigrants and refugees that are treated in a discriminatory way. So, for example, one of the obligations or the specific obligations that the states must do is abstain from carrying out any action that in any way, directly or indirectly, is aimed at creating situations of de jure or de facto discrimination. This translates, for example, into the provision to enact laws in the broadest sense, formulate civil, administrative, or any other measures, or encourage acts or practices of their officials in implementation or interpretation of the law that discriminate against a specific group of persons because of the race, gender, color, or other reasons. In addition, states are obliged to take affirmative action to reverse or change discriminatory situations that exist in their society, in their societies, to the detriment of a specific group of persons. This implies the special obligation to protect that the state must exercise with regard to acts and practices of third parties who, with its tolerance or acquiescence, create, maintain, or promote discriminatory situations. Because of the effects that come from this general obligation, a state may only establish objective and reasonable distinctions when these are made with due respect for human rights and in accordance with the principle of applying the norm that grants a major protection to the individual. So one of the results of the foregoing is that in their domestic laws, states must ensure that all persons have access without any restrictions to a simple and effective recourse that protects them in determining their rights, irrespective of their migratory status. In this respect, the state must guarantee that access to justice is genuine and not merely formal. So due process of law is also a right that must be ensured to all persons, irrespective of their migratory status. And non-compliance with these obligations gives rise to the international responsibility of the state. And this is exacerbated insofar as non-compliance violates peremptory norms of international human rights law, like the principle of equality and non-discrimination. So the general obligation to respect and ensure human rights binds states regardless of any circumstance or consideration, including a person's migratory status. It is also worth to point out that these specific obligations are applicable to all states, regardless of whether they're a party or to an international treaty such as the American Convention on Human Rights or the International Covenant on Civil and Political Rights, because the principle of equality and non-discrimination belongs to the realm of jus cogens and is of a peremptory character binding all states. Consequently, states may not discriminate or tolerate discriminatory situations that prejudice migrants. However, the state may grant a distinct treatment to documented migrants with respect to undocumented migrants, or between migrants and nationals, provided that this differential treatment is reasonable, objective, proportionate, and does not harm human rights. For example, distinctions may be made between migrants and nationals regarding ownership of some political rights. States may also establish mechanisms to control the entry into and departure from their territory of undocumented migrants, which must always be applied with strict regard for the guarantees of due process and respect for human dignity. So with all these considerations, we can make a set of considerations that are globally applied to almost all states in the world. Of course, depending the specific case, may appear some new obligations for the state in regard to the migrant or the refugee person that is subject to its jurisdiction, right? So based on these considerations, we can formulate the following set of conclusions in relation to this problem. First, the adoption of discriminatory policies or measures by states towards certain groups of migrants or refugees is a common practice today and needs to be truly discussed to put an end to it. And second, the principle of equality and non-discrimination is today a norm of jus cogens and is therefore applicable in all states, regardless of the ratification of a specific international treaty. In third place, distinctions in the treatment of certain migrants or refugees are permitted, but as long as it pursues a legitimate aim, is proportionate, and is provided by the law, as well as it needs to be necessary in a democratic society. If those kind of distinctions, if those kinds of measures doesn't have all these particular requirements, it will be a discriminatory measure, and of course this will imply a violation of the human rights of the person. In fourth place, apart from the general obligations to respect and guarantee human rights, certain specific obligations are rights for states in relation to migrants and refugees, such as access to an appropriate and effective remedy to process their immigration status and avoid being deported, or adopt measures of all kinds to avoid any form of discrimination against them. And finally, failure to comply with these obligations can result in the international responsibility of the state before international human rights tribunals, such as the Inter-American Court of Human Rights or the European Court of Human Rights, and even for states like the US or some European countries or some Asian countries, African countries that doesn't are part of these international treaties or these international organizations. We have also the United Nations treaty bodies that can see any kind of this situation, any kind of these discriminatory issues that occur in these states, and can determine the international responsibility of the state that doesn't provide a protection to the migrant and refugees against discrimination in its jurisdiction, right? So that was my presentation. I apologize for the video. It was a really fun one, but I thank you very much for your attention.
No worries, Carlos. Thank you so much for your presentation and for your willingness and all the information you're willing to share with us. I now invite the four panelists we had this round to turn their cameras back on for question and answer for the last 15 minutes. Dr. Reed, I know you have some questions. I'll pass it off to you.
Yes, I'll begin with some questions that I think, I hope will provoke some discussion among you all. And that is, I'll begin with Ms. Greising, and I'll point out that we heard in our very first panel, the nation of Turkey has taken in over 3 million refugees from Syria. Turkey is nowhere near the size of the United States. The nation of Jordan, a much smaller nation than even Turkey, has taken over 1.5 million refugees from Syria. And Ms. Greising, as you well know, the number of refugees and asylum seekers the United States takes in is a tiny, tiny fraction of the numbers taken in by other nations. Our problem, therefore, seems to be a problem of political will. So how do we begin to reformulate? How do we begin to change the political will in this country toward one that is more welcoming of persons who are in desperate, dire need? That's my question to Ms. Greising. My question to Ms. Davis-Scherf and Jeff Heitkamp is similar, and that is we need to develop a new vocabulary that recognizes that reformulates, recaptures a spirit of welcoming. And Jeff, in particular, your desire to return to Scripture, I think, is a sound one. I might add that within the Catholic tradition, there is a strong movement, certainly led by the Pope Francis, towards a welcoming of refugees, and perhaps it is one of political will. But the Catholic Church could certainly do a great deal, has done a great deal, but could certainly do a great deal more in the area of welcoming refugees and asylum seekers, and perhaps changing the political vocabulary and the climate of opinion in this country. Finally, my question to Professor Santana Moreno is I enjoyed your reference. It was far too brief. I'd love to hear you expand on this and to perhaps engage our other speakers. Your reference to intersectionality as a source, as an idea standing behind discrimination. Intersectionality, of course, is the idea that that tries to unite, critical race theory tries to unite modern feminism into a broader nexus, broader set of relationships. I'd love to hear you expand on that some more, and perhaps engage some our other speakers on that topic. So I leave the conversation to the four of you. Please have at it. Thank you so much.
Ms. Greising, if you'd like to lead us off.
Yeah, I mean, it's such an easy question. How do we completely change how our political system is functioning? Yeah, I mean, I would argue it's somewhat political will, but I think if we look at numbers of respondents who say we should have a welcoming immigration system, and the number and the kind of capacity of states, individual US states to respond when they've had the opportunity to, individuals who have sponsored Ukrainians under the Uniting for Ukraine program, and the folks who are signing up for the Refugee Welcome Corps. I think we have a political will within the people, but a gap between the political will of the people and what our leadership is doing. So I think one big thing that we're focusing on at the Advocates is trying to conceptualize systems of welcome that shift the power structure from states that have a significant number of migrants at the border, for example, and are therefore able to wield a lot of power in the conversation about how we structure our immigration system because they appear to be kind of on the front lines, If we shift our welcome system so that every state had a greater share of that burden, then I think we'd see kind of less power kind of concentrated into these very anti-immigrant communities and anti-immigrant leaders. And that might help us kind of move the conversation forward so that we were able to kind of look at policies that more people agreed with, rather than letting the discussion be completely driven by folks who maybe don't represent what the majority of America looks like. I mean, that's the case with gun laws and all of these things that we probably need to shift the focus on. But I think that's a good starting place. And I guess I'm somewhat hopeful that some of the responses that we've seen in the recent couple years might help do that as we look towards elections. But yeah, if anybody has the actual silver bullet to shifting the political will.
That is a good first step, is relieving the crisis atmosphere at the border and spreading out, not necessarily the burden, spreading out the welcome.
Yeah, the opportunity, right?
Burden, but the opportunity.
Yeah, I think particularly the polarization in America, where the left attacks the right for being sinful and evil, and then the right attacks the left for being woke, and it turns into this harsh polarity. If the moral language can sometimes turn from sin and condemnation to a language of hope and opportunity, to say that we have a moral opportunity for generosity, picking up on some of what Lindsay says, that becomes a more constructive conversation rather than a conversation about blaming. And that might start more at a theological or even a pastoral level, or whatever those equivalents are in secular society, because the mutual condemnation is an absolute dead end. And insofar as being anti-immigrant becomes sort of code for just being anti-democrat, you're probably never going to win hearts and minds. But when there's an opportunity to open up to generosity of spirit, you suddenly create a place where people can have a shared political vision.
I completely agree with what both Jeff and Lindsay said. I'm going to be honest, when it comes to any kind of immigration policy or advocacy or lobbying, Lindsay is the person I defer to anyway. So I think she's kind of the leading local expert in that, and probably nationally too. But one other thing that just comes up all the time, just as I'm just an immigration attorney, this is what I do all day, every day. And one of the things that comes up all the time and that frustrates me is there's so much misinformation about, that's why I think Jeff and I and Lindsay had the exact same attitude about a lot of these things, of the so-called border crisis. I don't think it's an actual crisis, except in the way that we're treating people and that we're creating these problems. But there's so much misinformation. So I have just so many clients. I primarily practice business immigration law, and I have a lot of clients in a lot of different industries who are very conservative, and who I just don't really get into about this, about immigration a lot of the time. But you have no idea how often when I'm talking to those employers, the HR departments, the owners of companies, that they keep saying their immigration problems, their inability to get workers is because it's so hard to do this the right way. But then there's all these people coming in on the southern border, when that just is not based in, there's no reality at all to what they say. And of course, I don't just want to engage in political debate with my clients. That's not really productive. But I agree, it is too hard for them to get workers. But it has absolutely nothing to do with that. And the idea that we're just letting all these people in the southern border, not to mention the fact that probably a lot of those people are actually working for them, in that a lot of industries I work with have a lot of people, undocumented people, or people, unskilled labor. So, and then of course, they're the same people who call me and say, hey, this person they know is probably undocumented, has been working for me for 20 years. Why can't I help them? And it's these are the same issues. Once you know them personally, then you always think there's an exception for that person. But I think there's just so much misinformation about immigration law, and especially the border crisis, that I don't really know how to get over that, given the polarization in our country and a lot of just misinformation out there. But I think that's an obstacle that must be overcome in order to go to a more normal conversation where we can actually do something about the border.
Yeah, well, Lindsay, Rachel, and Jeff are obviously the experts in terms of this, especially in the US. But I really agree with what Rachel just said about the main issue is to how we treat people and how we think about immigrants and refugees. Because, for example, really stick with me the example and the measure that Jeff said about the app that on the phone, because that is a political measure or an administrative measure that is aimed to a specific kind of migrant and refugees. You know, it is directed to a migrant or a refugee that can afford to have a cell phone and a smartphone and have internet, Wi-Fi. And for example, I'm here in Colombia, I don't have internet in my smartphone, you know, and I'm a lawyer and all that, but I don't have that privilege. And this also will happen to people from Guatemala, El Salvador, Venezuela, Mexico, etc. So the main issue is how we treat people and what are thinking about immigrants and refugees. And here I make the link with the question of Professor Charles about intersectionality, because when we think about immigrants and refugees, we tend to forget about the past of this person, or forgot about what this person is, are their beliefs, their religion, their race. And sadly, I cannot show you the video that I prepared for the presentation, but in this video, it shows very clearly like Black persons, Black men that were flying, that were leaving Ukraine from the Russian war, were stopped by authorities from Poland and all neighbor countries just because they were Black, just because they need to stay in Ukraine to fight for it. It doesn't matter if this person was from El Congo, from Kenya, it doesn't matter. Just because you are Black and you are from Africa, you must to stay here in Ukraine and defend us, the white people, you know? So these kind of issues need to be addressed, and hopefully the states can take measures that can aim this issue.
Well, thank you all, and we have about 2 minutes left. Austin, are there any questions from the audience with 2 minutes to go?
We got one, well, I guess one compliment to Lindsay for her presentation.
Says you're awesome.
Yes, says you're awesome.
In all caps.
And we had another question that I was asking where they can find these papers with more detail about the content.
There, of course, they'll be published in the Journal of Law and Public Policy, University of St. Thomas Journal of Law and Public Policy, which will be online, and we have an open access journal policy.
So those articles should be available in the coming months on our website. So that is all the questions that we have for you at the moment, right on time at 11:30. So I just want to thank you all again for your contribution, your willingness, and your interest to participate in our symposium. I learned a lot. I know Dr. Reed learned a lot. Taylor, would you like to say something?
Yeah, I think from these last these talks, main thing we talked about was just treating people with respect and as humans. And I think that carries over also into the words we choose to use and how much power the words we use and associate with things have. So that's just something I'd like to leave everybody with as we go to lunch, is think about the rhetoric that you're using and how it's being applied to things and how that's influencing people around you, because many of us are in not necessarily positions of power, but positions that a lot of people look up to us in. So as we go to lunch, that's just something I'd like to leave everybody with. So thank you very much. And we'll be back at 12:15.
Yes.
12:15.
Wonderful. Thank you again, everybody.
Thank you so much. Thank you.
All right. Hello, everybody. Welcome back to the University of St. Thomas School of Law, Journal of Law and Public Policy on our Spring Symposium on the immigration and refugee crisis. We're happy to be back after filling lunch. We will go ahead and get started with our third panel of the day. I will read off some biographies, and then I will ask the panelists to turn their cameras on and unmute themselves. So the first panelist that we have is Raymond Akije-Moa. Raymond is in his last year of graduate school at the University of West Florida, where he is studying history. Before attending the University of West Florida, he earned a Bachelor of Arts degree in History and International Studies from Imo State University in Nigeria, where he graduated in the top 10% of his class. His specific interests are in the 19th century forced African migrations, the transatlantic slave trade, the Atlantic world, the African diaspora, the modern transnational migrations and immigrations. Through his studies, he hopes to contribute to closing the gaps in African historiography and migration research by connecting his historical research to pressing contemporary concerns and articulating its broader importance. Secondly, we have Ali Tero. He is of Iranian descent who immigrated to the United States. While studying political science in Iran, Ali promoted democratic values and organized students for the Reformist Party. As a prominent campaigner and human rights activist, he was targeted and imprisoned by the Iranian regime during the Green Movement uprising. A day after the 2009 election, he was arrested and placed in solitary confinement. Following his release, he was banned from continuing his studies and feared further imprisonment for any promotion of human rights. He fled to Turkey and registered with the UNHCR as a refuge. His lived experience as a political prisoner, human rights activist, and refugee have motivated his expertise and interest in international refugee and asylum law. Ali is a doctoral candidate in law and policy at Northeastern University and serves as the director of operations at Asian Human Services, which provides secondary services to refugees and immigrants. And lastly, in our panel, we have Bashar Malakawi. He is a global professor of practice and law at the University of Arizona. He received his SJD from American University, Washington College of Law, and LLM in International Trade Law from the University of Arizona. Excuse me. He is well-versed in teaching and providing legal advice with over 20 years of experience in private and public sectors. He has written over 70 law review articles and professional publications, which have appeared in top-tier journals like the Journal of World Trade, Harvard Negotiation Law Review, American Journal of Comparative Law, and Journal of World Intellectual Property. He has served as a consultant and expert witness for USID, the World Bank, International Trade Center, and international law firms. Those will be our three panelists in this third round. And I would first like to welcome Raymond to kick us off. Let's see, there you are, welcome. If you have any slides, you're free to share them now. Otherwise, you can begin your presentation when you'd like.
All right, thank you. Let me share my slide. Yeah, can you see my slide?
Yes. Yes, you're good to go.
All right, thank you. Thank you so much, Austin. We have been in constant communication right from the time I got to know about this conference. And thank you to the University of St. Thomas School of Law for giving me this opportunity to share my research. It's my ongoing research. And Austin, when we have been talking, I told you I'm in my last year of grad school, but right now I'm an incoming PhD student at Georgia State University. Yeah, so my research is going to be summarized in a few minutes. It's going to be contemporary irregular maritime migration from Africa to Europe. This particular research is very important to me because I'm from the sub-Saharan Africa, and I have had people who have lost their life on top of the sea in an effort to better their lives in Europe. So this, I'm gonna start, let me share my slideshow. So irregular maritime migration from Africa to Europe, it has been there, for the fact that some countries in Africa today, they experience unrest and forceful military enlistment. So it makes a lot of people, especially the young people, to want to move. But when they want to move, they don't have the resources to go through the legal path. So there are some agents who are right there at Agadez, which is their meeting point, telling them that there's a better way in Europe. And most people think that instead of me to stay here unemployed or be forcefully enrolled in the military, it is better I go on top of the sea than doing that. So this migratory pattern has been there. So I broke the whole thing down into two. I call them the push and pull factors. So for every illegal migration, there are some push and pull factors. And these push factors are what we are calling the unemployment, military, forceful enlistment into the military, absence of affordable healthcare, low quality education. These are the main drivers of this rapid migration, especially from third world countries. And look at the pull factors, look at the good opportunities. So most of these illegal migrants, they think that in Europe, there is a mystical Eldorado. There is a better life in Europe. So most of them, these two factors are the main thing that drive these people to move illegally. So my research as well tries to contrast the media reportage that these people are moving or are leaving Africa because they are desperate to leave. Of course, the choice to move is complicated. So that's why I had to break them into push and pull factors. So looking at the viewpoints and novel approaches of this illegal migration, I mentioned unemployment. So if someone is unemployed, they won't have a good means of income. And when the government is not taking care of the youths properly, no provision of basic care and everything, they leave the country. So I as well see this, the absence of youths, the workforce in a particular region causes what? Brain drain. So conflicts. I'm from Nigeria, and the northeastern part of the country has driven a lot of people to leave the region because of conflict. So when there is conflict, like we have the Boko Haram, which is disturbing the northeastern part of Nigeria, so a lot of people have been displaced. The young generations have moved. So when they have the opportunity to hop on the ship, most of the rickety ships or inflatable rubber materials, they go there. But what happens on that? Some of them perish. In 2015, almost 2,000 have lost their life on top of the Mediterranean Sea, even as the contention of refugee policies in Europe and the way Europe and Africa could synergize to curb the illegal migration. So look at the good environment. Most countries in Europe, for example, Germany, Spain, Italy, they have some affordable healthcare. So most people, when they travel, they believe that when I go there, I'll start up a new life. I will forget everything I have acquired in my origin country, but there is a better life in my destination country. So you see these young people, they have this drive, they have this bravery, they have this resilient attitude to forge ahead of the sea. So my research as well is trying to paint a picture of resilience, bravery, and heroism in the life of these people who move aboard sea to Europe. So I will discuss a little on the methods of my research. So to bring this research together, I have employed the use of secondary sources, and I'm working on getting through some primary sources like reaching out to the University of KwaZulu-Natal in South Africa and the WITS Center for Migration Studies. They have a lot of research repositories on African migrations. I'm using monographs, photographic evidence, which we will see as we move on in this research, and some textbooks which I'm using to put my research together. So what are the patterns of this migration? So recently, movement to Europe has been portrayed as a rush of people in distress, starvation of war at home, searching for their mystical Eldorado. But European nations, I would say the EU, have stiffened their borders, and they have layers with most of the transit countries in Africa. The transit countries in Africa are Libya and Morocco, and as well Turkey, because most of these people, when they meet at the meeting point in Niger, they walk towards the big Sahara Desert and they move towards their transit points. But what happened at the transit points in Libya and Morocco? Most of them are enslaved in the modern day slavery, or most of them are sold to the Middle East, or some of them are jailed. So to do this, the EU have synergized with these transit governments to make sure that they stop this inflow of migrants into the EU. But the African Union, what are their efforts? Are they really interested, or are they really serious in stopping this inflow of migrants from Africa to Europe? Of course, the answer is yes and no, because the EU most of the time funds these transit countries to stop these people from moving in. But what about the businesses in Europe who needs these people to come in? Of course, cheap labor. They need these people to come in. So I'm going to say that the move to stop illegal migration is not stopping soon, because the destination countries still need these people to come in for cheap labor. In my subsequent research, I want to move forward to contrast and to compare this with that of Central American migrants coming to the southern border, for example. You know that when it comes to immigration, undocumented immigration in the US, for example, it's not stopping anytime soon. Yes, the government would say undocumented immigration, stop and all that, but most businesses in the US are short-staffed. But who fills these gaps? These undocumented immigrants. The same way in Europe. So it is just on paper that the government and the EU, the African Union are just putting up there to stop this illegal migration and all that. But the UN bodies are still doing their own best to make sure to curb this, because most of these illegal migrants think that it is better for them to be at sea for months moving than to be in their origin countries. So I'm going to share some pictures. You can see in the picture. Look at. You can see look at the blue picture there. You see a lot of these illegal migrants packed shoulder to shoulder in their rickety boats. Then I'm going to share another one where most of the UN bodies like UNHCR, IOM, they are rescuing people on the sea. So these people are doing their best to do what? To support these people through psychosocial support, because living life at sea for a month, trying to cross for greener pastures, it's something that the origin countries do not know anything about, and even the destination countries. So these bodies are at sea trying to save life, while most countries too send out pirates who cause shipwrecks. So most of the shipwrecks we see aboard ship, it is not ordinary. Most of them happened because of what? We don't want these people to move in. So you can see here, these are a bunch of young people, energetic people, who just arrived the enclave of Quetta. Quetta is a northeastern port city of Spain. It shares borders with Morocco and the Atlantic Ocean and the Mediterranean. So once these young people, they get to this point, you see joy, you see bravery, you see resilience, you see that they are hopeful that they're going to cross. But Quetta is heavily protected by the Spanish army. But when they get there, they still find their way in. So the strong spirit of these migrants made them to kind of, most of them have backup plans. If they are the people who try to push them, for example, agents who traffic them, tell them that, come together, you have to pay $1,000 for us to take you to Spain. You have to pay $500 for us to take you to Italy. These people have backup plans because sometimes when they get at the middle of the sea, they leave them. So when they leave them at the middle of the sea, what do? They keep pushing it because they believe that even though the people that kind of like lured them into this journey left them at the middle of the sea, they will get there because they believe that Europe has better offers for them who are young people. And when they get to Europe, they think about their families back home because that is what most of them like left home for, to feed home. So I want to read out some of the primary sources that I got from some libraries and how people gave their experiences in the course of this travel. I want to look at Peter. Peter was not the only person who had found his way to Istanbul. A woman from Liberia in the company of a little girl admitted how she had nearly boarded the inflatable migrant raft off the Aegean coast of Turkey, which was meant to transport them to Greek island of Lesbos after she became anxious and nervous. In her words, in quotes, I said, no, I cannot do the same with my baby. I cannot. She explains her decision. I believe both myself and me crossing the sea with such a little baby is not a solution. So this woman, because of her baby, it's kind of like deterred her from crossing the ocean with her little baby. But Peter, who was in transit in Istanbul, was easily like influenced to cross. So these are ways that people who see how people have crossed without somebody or anybody deterring them. So the younger ones, like these people you see in the pictures, they are easily influenced because they don't have any baby, they don't have any wife. So they hop onto the ship, not minding the state of the ship or how the ship is, they move because they want a better life. So I want to look at the strategies that the European governments and African Union are doing to curb this illegal migration. So they are putting up some security checks. So the European member state has extended good gestures in Africa to solve remote and immediate cause of these illegal migrations. So cut down the people moving to Europe. The European Union sought to externalize the securitization of her borders in Africa. How did they do that? They have shared between the nations of origin, the transit countries. For that purpose, a conference which was held in Malta in 2015 brought African states together to discuss more on ways to address this illegal migration to Europe. So European Union, from that conference in Malta, in Valletta, Malta, they provide funds to these origin countries. They provide funds to these transit countries to make sure that these people are not allowed entry into their various European nations, because they believe that illegal migration or undocumented migration poses a great threat to the national security, to the economy. But in contrast, most of the European businesses needs these people to come in. So look at this. You can see the type of boat these people use. I call them rafts. I don't call it boat. I call them, these are rafts. So you can see the rescue operators trying to rescue them in this. So these are precarious boats, well arranged by some agents fueling this illegal migration. Sometimes, if you see, last week, there was a Mediterranean shipwreck. About almost 42 people died in the coast of Africa who are trying to move to Europe. So when they go into this type of thing, sometimes they encounter pirates and their raft gets deflected. So these are great things that migration researchers have to look into. But in my own opinion, I always argue that migration research is underrepresented. It is underrepresented because most people who are engaging in migration research are non-governmental organizations. But look at the Atlantic world today, Europe, Africa, and America. Every government have a clause in their constitution that has to deal with migration. Of course, you cannot stop migration anytime soon, because for the fact that human beings exist, migration is inevitable. People will move, crisis will come, conflict will come, and people will try to live for a better life. My major is history, but as I am advancing in my studies, I am seeing the reason to include migration in my research. So there are ways. This is kind of like a little suggestion in terms of migration research. There are ways migration researchers will be supported. One, most times funding to go to the hotspots to go and do proper research on migration. It's limited because enough attention is not given to migration researchers. Every government is talking about migration. Every country is talking about migration. Every region is talking about migration. But there is no resources for people to go to these transit hotspots to do proper research and documentation on migration. Even the non-governmental organizations are more interested in data collection, not on proper migration research. So my research is trying to fill in this gap that this researcher is seeing in migration research. To come to a conclusion in my little research, I want to say that transit countries have transitioned from out migration to border control hubs for illegal migrants seeking to enter Europe. Many people have risked their life in boat accidents. For example, I'm going to bring it down to the region I'm in right now. A couple of months ago, a Haitian should I say a pilot or something? Someone designed a kite or something and flew from the Caribbean into Florida Strait illegally. The last time, boats coming from the Caribbean capsized close to the Florida Strait. You see people coming from Central America to the southern border. Some of them, you see a bunch of people who die in their boxes, in different things. What are the things, how do the government integrate these people? How do the government assimilate these people? What strategies, what frameworks are in place? What about the linguistic differences? How do these people integrate into their new community? So even though migrants have embarked on dangerous maritime journey in various regions of the world, the situations in the Atlantic Ocean and Mediterranean Sea are hazardous. Migrants from Africa traversing the Gulf of Aden and Red Sea into Yemen face complex problems. The African continent is surrounded by water, where the sea is a primary route for people fleeing insurgency, unemployment, hunger, impressment, which is one of the reasons most countries in sub-Saharan Africa, their younger citizens are run away from impressment. So there was a video I saw about the footage of John Bowden, the captain of United States Coast Guard, where there was in a news article.
Hey, Raymond, people. Finish up in about the next minute, please.
Okay, that 8 people were missing in an ocean. So, in conclusion, therefore, so as migration experts, so I am open to learning more of the frameworks and policies and approaches to assimilate these people into their new environment.
Thank you. Thank you.
Yeah, thank you so much, Raymond. Greatly appreciate your time and effort and contribution to the symposium. We'll save the question and answer until we finish the rest of the panels or the rest of the speakers for this panel. So this time you can turn your camera off, mute yourself, and we'll move on to our next speaker, Ali Tarok, my apologies. Yes, there you are. Welcome. You may unmute yourself and share your screen if you have any slides you'd like to share.
Yeah, thank you for having me. Okay, hello, everyone. I am Ali Tarok. I came to the United States 10 years ago as a refugee, and I started my journey in 2011. I fled to Turkey, registered in UNHCR in Ankara, and I stayed there for 16 months. After 16 months, I flew to Chicago, December 10, 2012 at 5:23 p.m. Chicago O'Hare Airport. It was a very important moment in my life. That's why I remember every second of that moment. I am a doctoral student in law and policy at Northeastern University, and today I'm going to present to shed light on the new aspect of southern border crisis. It's about Afghans. We have Afghans at the borders. So my topic is U.S. policy as the abandoned asylee U.S. policy as applied Afghans at the U.S.-Mexico border. And this presentation contains 3 sections: issue overview, legal and policy overview, and my recommendation. there is not that much study about this crisis because it's very new phenomenon. And I know USCIS is involved with an ORR office. They are trying to work with some law firms and solve the issue. However, it's very complicated immigration issue. So, and for the beginning, probably most of you know what happened last year, the US evacuation from Afghanistan. And the last year in the Trump administration, they negotiated with the Taliban to withdraw the troops and their allies from Afghanistan. Okay, in the first year of the Biden administration, they implemented the protocol, and it was that chaos. And as I said, probably many of you saw those videos and terrifying footages. So when the evacuation process started, the United States took some Afghans to US military bases or lily pads across the world and other countries to facilitate their resettlement in the United States. Some countries such as United Arab Emirates, Germany, Qatar, and other countries issue some humanitarian visas, some for Afghans, such as Brazil. And according to New York Times report, more than 98 countries pledged to accept Afghans after US departure. So the evacuation process is defined under Operation Allies Welcome, or OAW, sometimes referred to as non-combatant evacuation operation, and EU, which the Department of Homeland Security is in charge of implementing. So again, everyone was evacuated under Operation Allies Welcome. Everyone evacuated to the US military bases. Okay, were given a humanitarian visa and parole in the United States. And according to New York Times, more than not more than 98 countries have helped United States in these operations. The legal status now for the Afghans who have arrived here, they are identified as a parolee Afghans. So evacuees into the United States received under the Section 212 D5 of the Immigration and Nationality Act, which is temporary designation that includes work authorization, access to public benefits, and ability to apply for a permanent legal solution, such as asylum or immigrant or a special immigrant visa or SIV. So, and etc. Eventually, they receive their legal permanent residency or many of us, we call it green card. So the point is, Afghans are here, they are parolee, means they don't have immigration status. Okay, they don't have visa, they don't have asylum, they are not refugees, and parolee is not an immigration status. So the permanent legal solution given to Afghan resettled in other countries, such as Brazil, okay, as I said, issuing humanitarian visa. According to the Brazil law, Afghans who are in Brazil, they will be eligible to apply for refugee status, which we don't have in this country. So the parolee cases, or Afghan with parolee, they can be eligible to apply for a special immigrant visa and asylum. So why I submit my proposal for this symposium because we have a crisis at the southern border. We have around 1,000 Afghans at the southern border. For the first time, when I heard about Afghans at the southern border, I was shocked. Okay, I couldn't believe it. Afghans from the other side of the world, they are not inside the US, they are at the border, US-Mexico borders. Guys, how? Okay, it's impossible. Then I realized that other countries try to help United States, okay, with that terrifying moment. So Brazil issued more than 4,000 humanitarian visas for Afghans. Okay. They brought them to Brazil, okay, and Afghans in the Brazil, they realized, shoot, we work for the United States, okay, our lives was in danger, okay, they promised us to take us to the United States, and now we are at in Brazil, and there is a very limited chance to stand on their own feet and build their life over there. The language barriers, cultural barriers, and the lack of work opportunity, education. Then they decided, because they communicate with their friends inside the US, okay, they hear about the benefits of living in this country. They decided to take that long journey and very dangerous from Brazil towards the United States. And as you see, the most dangerous part is the Colombia and Panama border. Is all jungles. There is no route, no road, no civilizations, and these people have to pass this border or barrier gap. And many of people they cannot survive in that journey. And interesting thing is 4,000 were granted to stay in Brazil, and half of them already left the country. Means 2,000 Afghans, okay, around 2,000 Afghans arrive at the border. And so they started this dangerous journey because they thought, okay, they are entitled to apply for SIV or a special immigrant visa, or if they pass the border, okay, they can apply for asylum. So, but there is a legal issue. There is a huge issue at the border. Afghans from Brazil, okay, we'll start from their journey from Brazil, they are not parole. Okay, United States didn't bring them inside the US. So they are not eligible for many benefits, okay, the ORR benefits or other things. They are not eligible to apply for asylum because they are not inside the US. And also, I will explain later, it's very challenging for them to apply for a special immigrant visa. So the issue is, if they pass the border, the ICE or US Immigration and Custom Enforcement, they go after them, okay, take them to custody to deport them, okay. At the same time, ORR wants to provide services to them. However, two federal agencies, they cannot compete against each other. If Afghan pass the border, probably around 99%, there is a chance to get deported from the border, and they won't be eligible again to apply for asylum, even a special immigrant visa. This issue is a huge debate, negotiation, I know, inside the Biden administration. They try to solve the issue, work with the different consulting firm, law firms, but it's still existing. And also, parole cases, parole Afghan inside the US are facing a new crisis because their paroles was good for a year or 2 years. It's about to get expired. Okay. So there is no chance for them to get a permanent solution or green card. there is a different reason. I said in the earlier panels, okay, some of my fellows, they touch base about the asylum backlog or other issues. So, and also SIV cases, okay, it can be at the Afghan at the southern border issue as well. They work for US military or US company, that's why they are eligible to apply for SIV. However, after evacuation, those companies are dissolved, they don't exist. Means if I want to apply for SIV case, I have to have my employer, okay, to apply for me, okay, to tell, hey, yeah, Ali was working for me and he's eligible to get SIV. They don't exist anymore. Okay, they cannot claim, hey, I used to work for this company and okay, this is my evidence. And also many of Afghans, especially who are at the borders, they shredded their documents. Many of them because of Taliban, many of them because they were worried about their identity. They don't have anything to show, hey, you know, I'm eligible for SIV. And asylum seekers, you know, there is a backlog and the USCIS is overwhelmed, okay, and it takes a while to issue asylum for the asylum seekers. So, and also Afghan parolees are about to get deported, okay, or send them out from the country. One solution is Afghan Adjustment Act, okay, has been pending. Okay, so Congress is working on it, the federal agencies are working on it, but it's not passed yet. Okay, they are still negotiating about Afghan Adjustment Act or debate. There is an ongoing debate. So if it gets enacted, parolee cases, they will be eligible to apply for asylum. They will be eligible to get their green card, okay, in the shortcut. But this one, there is the Afghan Adjustment Act is still pending, and there is moral and ethical obligations. These Afghans inside the US and also especially at the borders, they serve US militaries. They help us, okay, for 20 years. We promise, they put their life in danger. We promise them, hey, you help us, we will help you. And this is now, especially Afghan at the border, they have no status, okay? And this is the federal government responsibility to take care of these cases. And also, they need to pass the Afghan Adjustment Act as soon as possible. My recommendation is, okay, it can be law firm people or consulting firm people to add more content to Afghan Adjustment Act to cover the Afghans at the borders. Means if they pass the border, ICE won't be able to go after them and deport them, but they can be protected or have amnesty under the Afghan Adjustment Act and apply for their permanent solution, which is a green card. And yes, so thank you for listening to my presentation. This is an ongoing issue. I'm working on it, and hopefully USCIS come with a solution. However, in the meantime, we have a severe crisis, Afghan crisis at the southern border. Thank you for listening to me.
Thank you so much. Thank you for your presentation and your contribution. Let's see, Ali and Raymond, if you could turn your cameras back on, we'll jump to question and answer now. And I will shoot our third speaker an email to see if he has lost his Zoom link.
Raymond, let me begin with you, and then I'll move to Ali. But Raymond, let me ask you, there was a time, well, 100 some years ago, when the United States, at least with respect to Europeans, it was different with respect to Asian immigrants and African immigrants, of course. But at least with respect to Europeans, the United States had essentially an open borders policy that anyone who could come to the United States, by and large, was permitted to enter the United States with a few exceptions, but not large exceptions. Should the EU adopt a policy of open borders? Should the United States, for that matter, adopt a policy of open borders? Knowing that there are trade-offs, and the biggest trade-off, of course, would be the issue of suppressed wages. Free mobility of persons would also have the effect of suppressing wages. So we know there would be a trade-off there. But should we adopt a policy of open borders? That's one question. And then a question for Ali Tarok, and maybe an observation regarding the course of your research. I will flag 2 episodes in American history where the United States made large accommodations for refugees. Hungary in 1956 and Vietnam after the conclusion of the Vietnam War. In Hungary in 1956, it was the height of the Cold War, and the United States enthusiastically cheered on the Hungarian Revolution of 1956. The revolution quickly collapsed, and there was a sense of moral obligation following that to make welcome refugees from Hungary. And as a consequence, as we heard in our very first paper this morning, that was done. Secondly was the end of the Vietnam War. And again, there we had a large numbers of refugees fleeing Vietnam, and gradually the 1980 Refugee Act was enacted. And again, welcoming into the United States large numbers of Vietnamese refugees. Again, because of the strong historical connection between the United States and Vietnam, because of the American involvement in the Vietnam War, and because ultimately of the failure of the American response in Vietnam. Finally, there is Afghanistan. Afghanistan looks to be quite similar to Hungary and much even more similar to Vietnam. So I might encourage you in preparing the final draft of your paper to draw those historical analogies and make firm, I think, a moral case that Afghan refugees should be treated in the same way as Hungarian refugees and Vietnamese refugees after the conclusion of those crises.
Yeah, of course. So your question is that the US has open border policy. So you're asking if the EU should adopt such policy. Is that your question?
The question is, should an open borders policy, nations do not right now have open borders policies. A century and a half ago, nations did. Should an open borders policy be the policy of a particular nation state today?
Well, I will look at it from this way. So I wouldn't advise that every nation should just adopt open border policy, but tactical open border policy, it's what I will call it. Because if you have if you have tactical open border policy, it will reduce the violence and death tolls, So when you have borders, people who try to come in illegally, they perish. Some people who go through the sea, some people who go through the desert, some of them die, some of them have shipwrecks and all those things. So tactical open border policy, whereby those who can contribute to the destination countries will be legally screened and assimilated into the society. But I am not advocating for those who come in illegally, trying to forcefully enter, because some people might be traitors to countries' national security. But tactical open border policy will give room for professionals who will still contribute to their destination countries?
Ali, please.
Okay, the question is an analogy between the Afghan case and the Vietnam is a Hungarian case, right?
Yes.
So, yeah, I read those cases before the symposium, before I submit my proposal. There is some similarity, however, the time and the political environment, okay, everything has changed. Okay, that moment during the Cold War competition between two superpower countries, okay, we claim, okay, we are the leader of the free world, and we wanted to, we wanted to do something to show, okay, we are for human rights, okay, this is our values, okay, we care. But for Afghan cases, it's quite different, okay, it's not Cold War, there is no competition between two superpower countries. Okay, we invaded the country for to fight against terrorists, and we left. Okay, we don't want to take that much responsibility. However, okay, when we claim Afghans, okay, when we invaded the country, okay, we claim we are going to fight against terrorists. It means every single person, okay, who lives in that territory can be a potential terrorist. Okay, it brings up many security reasons, many security concerns. Okay, that yes, okay, we need to check. We need to add additional background checks, security for these individuals. Okay, or Afghans. So can we do it? No. Okay, we don't have that much data. Do we have capacity? Maybe. Are we going to spend money for them, okay, to just clear the background? No, okay. So that's why there is some hesitations against this nationality. And also the Ukraine-Russia war crisis, okay. Push back attentions from Afghan to Ukrainian. So the priority is how to help and how to help Ukrainian refugees, okay, instead of helping Afghans. So more attention is towards the Ukraine-Russia war, and these people are kind of disregarded. We can, as a historical evidence or witness, we can use those historical moments to push behind the Afghan Adjustment Act, okay, get enacted and solve some part of the problem. However, personally, I think there is some hesitations behind that.
We do have a couple questions. This one is for Ali. We have a question. Aren't Afghan asylum applicants guaranteed to have their asylum interview within 45 days of filing, thereby bypassing the year-long asylum backlog?
So according to my personal experience, there is no guarantee. Okay. There is no guarantee. There is no time frame. Okay. So and also there is no promise. For example, by the UNHCR regulation or USCIS, okay, I shouldn't stay in Turkey for 16 months. Okay, I was so lucky to left the country in 16 months. However, or even when you apply for your green card or citizenship, there is out of the time, and within 2 months we get back to you. Okay, but it never are never been accurate times. So, and what is the next question? Yeah, so my question for Ali is if you have identified a specific issue preventing passages up. As I mentioned, I think that, again, all the debates and discussions are behind the doors. There is not that much information out. I know because of my job, USCI is trying to work with some consulting firm, okay, and hire the immigration lawyers to help Afghan parolees inside the US, not at the border. And I heard some rumors that maybe they are going to extend their parolees time. But I think the issue is not a legal issue, it's a political issue. Okay, behind the Afghan Adjustment Act. I hope I could answer the question.
All right, well, seeing there aren't any more questions, I think we will call this panel to an end because our third speaker hasn't arrived.
Yeah, and thank you very much. And I think what we have now is a little longer break than we anticipated. We'll resume with our last panel of the day at 2 p.m. Central Daylight Time as scheduled. And please take the next 45 minutes and digest. We've had a wonderful, wonderful set of presentations. And it calls, I think, for a few moments of reflection and synthesis. So please do that, and we'll meet again in about 45 minutes. Thank you very much.
Thank you both. We appreciate your time and effort and participation. All right, welcome back, everybody. We're happy to be back for our fourth and final panel for the day. This panel will feature 3 professors, 2 of whom I know well, 1 of whom I'm excited to get to know more about. So I will give off some introductions, and then I will open up to the panelists. So first we have Professor Kimberly Breeden. She's an assistant professor of law at Ohio Northern University College of Law. Her research focuses primarily on the constitutional and international law dimensions of corruption or potential corruption by government officials. She has published articles in several major law journals and has presented her work at international and national conferences, symposia, and workshops. Last year, the University of Copenhagen and the Royal Danish Defense Academy invited Professor Breeden to present her paper, Disinformation, Corruption, and International Law, at a conference on Nordic perspectives on the international legal regulation of cyberspace. Professor Breeden earned her JD from the University of Cincinnati College of Law and her LLM from Columbia University Law School. And this is her 3rd time speaking at a St. Thomas JLPP symposium. So we're happy to have her back.
Yes, welcome home.
Yes. Next, I see we have Santiago Narvaez. She is an investigator for the Network in Defense of Digital Rights. She conducts research and advocacy and engages in strategic litigation on government surveillance in Mexico, focusing on its impact on human rights and the techniques used to criminalize and track migrants in Mexico and to prevent.
Well, is that Santiago or are you Laura? You're Laura.
Oh, Laura's on. Yes, Santiago and Laura's on.
There's there we are. There's Santiago.
Okay. Yes.
Sorry about that. I had to use Santiago's link.
Okay. I'll finish with Santiago and then I'll jump to your bio, Laura. Santiago engages in strategic litigation on government surveillance in Mexico, focusing on its impact on human rights and the techniques used to criminalize and track migrants in Mexico and to prevent people from reaching the United States. And we have Laura Bingham. She is the executive director of the Temple University Institute for Law, Innovation, and Technology, a globally recognized expert on nationality, migration law, and human rights. She engages in research, advocacy, and litigation on non-citizenship, cyber norms, and digital surveillance with a focus on the influence of geopolitics on multiple dimensions of lawmaking, justice institutions, and law enforcement. She has served as a senior managing legal officer with Open Society Justice Initiative, an adjunct faculty member at New York University's Center for Global Affairs, and has worked on transnational human rights litigation for the United Nations Human Rights Committee, the European Court of Human Rights, and the African Court of Human and People's Rights. So we're thankful to have you with us today. And lastly, we have Virgil Weepy. Virgil is a professor here at the University of St. Thomas School of Law. He grew up in Western Kansas and attended Kansas State University, where he received an honors BA in geography and political science. As a Rhodes Scholar, he received a MPhil, I think, is that a major in philosophy, in Latin studies from the Oxford University, concentrated in geography and economics. Weedy attended law school at New York University as a Root Tilden Snow Public Interest Scholar, an International Law Fellow, and an editor of the NYU Journal of International Law and Politics. After law school, he clerked for the Honorable James C. Francis in the Southern District of New York, and then served as a director of immigration services and supervising attorney for interfaith community in Interfaith Community Services in New York City. In 1999, he joined the Center for Applied Legal Studies at Georgetown University Law Center as an advocacy fellow, where he taught in the immigration clinic. And in 2001, he was appointed a visiting professor at the University of Maryland School of Law. So those will be our panelists for this round. We will start with Kimberly Breeden. Professor Breeden, if you would like to turn your camera on, you can share your screen and we can go from there.
Thank you to the University of St. Thomas Journal of Law and Public Policy, Charles, Austin, the whole student board for allowing me to participate in yet another fantastic symposium. It is my very great pleasure and honor to be with you here today to share some of my thoughts with you on the relationship between disinformation, transnational migration, and international law, and to hear your feedback and questions. Let's see. So disinformation has become a standard weapon in the efforts by authoritarian regimes and their ideological allies to dismantle multiracial, pluralistic, liberal democracy in the United States and across the globe. By disinformation, I mean narratives that are both deliberately false and intend to cause harm to a targeted group or individual. One particularly effective subject for these malign influence campaigns is disinformation that dehumanizes and demonizes migrants seeking refuge or asylum in other, often democratic nations by characterizing migrants as various kinds of threats to the destination state population's well-being. This type of migration-related disinformation all too often translates into anti-immigration policies in the states targeted by the disinformation. And my paper considers whether recent tightening of US asylum law reinforces the harmful false narratives perpetuated by migration-related disinformation and enables those narratives to undermine US commitments pertaining to global migration under international law, which in turn undermines the broader international law framework itself. So migration-related disinformation campaigns rely on highly emotive frames to exploit the public's fears and concerns about perceived threats to the domestic population's well-being. And false narratives about migrants typically employ one or more of the following frames: health, safety, security, wealth, and identity. Within the health frame, migrants are depicted as vectors of disease. For example, in the United States, migrants at the southern border were scapegoated for an increase in the number of cases attributable to COVID and resulting in increased hospitalizations and death during the summer of 2021. The safety frame casts migrants as violent criminals. This frame falsely portrays migrants as inherently more dangerous than the local population and more likely to commit crimes. Migration-related disinformation adopting a safety frame has been particularly prevalent in the United States throughout its history, but especially in recent years, as political candidates and elected officials have repeatedly disseminated false reports depicting migrants as savage or predatory. More specific claims falsely assert both that violent crime rates have surged in border towns in the American Southwest and that migrants are responsible for the surge. Related to, but distinct from the safety as a frame, is the theme that migrants pose a threat to the domestic population's physical security. This theme conveys the narrative that a significant number of foreign nationals entering as migrants are doing so under false pretenses, and that their real motive is to perpetrate acts of terrorism. And so by linking migration to potential acts of terrorism, this disinformation securitizes migration, thereby recharacterizing it as a threat to the security of the domestic population. The next disinformation theme relating to migration casts migrants as a threat to the economic security of the domestic population. Narratives advancing this theme create impressions that migrants somehow act as a drain on social services or create unfair competition for employment. False frames of migrants as a threat to economic security have a long lineage. despite study after study demonstrating that migrants do not adversely affect the earnings or employment opportunities of native-born Americans, it is one of the more persistent decades-long myths about migrants in the United States. The claim that migrants will take jobs that would otherwise go to the domestic population is in some instances linked to conspiracy theories. The conspiracy theories are often cast as a conspiracy by elites who want to import migrant workers, either because they work harder or they work for less money, or they are preferred for some other unspecified reasons. And I think one of the most insidious conspiracy theories relating to migration is known as the Great Replacement theory. This is a theory that implicates not only the economic threat theme, but also the last theme, which is that migrants are outsiders, they're other, they're different, and that they therefore pose some kind of existential threat to the national race, to the nation's majority race or religious identity of the host country. Now, not all narratives employing the identity theme embrace the Great Replacement theory, but it is one of the most robust articulations of identity-related threats, prompting fears among those who may already be primed towards xenophobic reactions to immigration. And often accompanying identity-related narratives is dehumanizing or eliminative rhetoric, which includes references to migration or to migrants with terms like invasion, assault, hordes, waves, floods, animals, savages, garbage, and the like. Effective migration-related disinformation influences public opinion in support of proposed regressive immigration initiatives. And when public opinion coalesces around certain policy preferences, lawmakers adopt statutory and regulatory frameworks in alignment with those preferences. And that often includes imposing greater restrictions on asylum and refugee eligibility. I'm going to use up all my time just trying to get from slide to slide. There we go. Okay, so through a chain of interconnected informational, psychological, societal, and institutional influences, immigration restrictive policy enactments resulting from successful migration-related disinformation campaigns both reinforce the false narratives perpetuated by the disinformation actors, and they also advance those actors' goal of undermining international law or democracy more broadly. Now, the depiction on the slide before you and my description of it is linear, but the process in reality is significantly more dynamic. But nevertheless, we're going to begin with migration-related disinformation, which uses false narratives to depict migrants through one or more of the threat-based frames. And this in turn may lead to a moral panic about migrants. Sociologist Stanley Cohen wrote the classic study of the manipulation of public discourse to serve a political agenda by generating what he calls a moral panic. And he describes a moral panic as, quote, a condition, episode, person, or group of persons that emerges to become defined as a threat to societal values and interests and is presented in a stylized or stereotypical fashion by the mass media. And I think we can add social media in 2023. A moral panic then shapes public opinion. Studies in psychology show that misleading narratives based on appeals to emotion, such as those that generate fear of harm, tend to have greater persuasive effects and are effective in changing or shaping attitudes if the audience believes that they can do something to mitigate the perceived threat, such as by supporting a politician who will adopt a protective policy. When public opinion on an issue reaches a critical mass among voters, political parties and politicians supporting a responsive action or protective action adopt and implement relevant policies. And parties and politicians who had previously opposed these responsive policy initiatives sometimes abandon their prior positions to align with the public opinion that is coalescing around more regressive approaches. Now, I should note here that public opinion does not have to be a majority opinion in order to constitute a critical mass for political or electoral purposes. But governments or political leaders in democratic societies who disseminate disinformation and create moral panics to justify pursuing particular policy goals often, though not always, use those policy goals or use those policy initiatives and responses to hide other goals. Sometimes these goals are relatively benign. Sometimes politicians just want to improve their political standing among a subset of voters to try to secure election or re-election. But sometimes they're more nefarious goals. Sometimes they're goals that would further a would-be authoritarian leader's aspirations for anti-democratic power or weaken the international law framework that supports and advances the rule of law or human rights protections. And even when the restrictive immigration policies adopted in response to the moral panics that have been created by migration-related disinformation do not themselves violate international law, they nevertheless may contribute to its erosion by diluting the effectiveness of substantive protections afforded migrants, by weakening the will of the international community to enforce accountability mechanisms for other state actions that may themselves violate international law, and by calling into question the legitimacy of international law more broadly. So I want to share some examples of immigration policies that have violated certain aspects of international law. So these should be familiar to folks. We've got the Muslim travel ban, the family separation policy, and the transit ban. The Muslim travel ban refers to a series of the Trump administration's executive orders promulgated in 2017, which prohibited travel and refugee resettlement from certain predominantly Muslim countries. After several legal challenges, the Supreme Court wound up upholding most of the provisions of a third version of the ban. But the international law violations are still sort of percolating out there. The policy was discontinued by the Biden administration. Similarly, the family separation policy was a policy adopted by the Trump administration in 2018 and separated more than 5,000 children from parents who entered the southern US border without immigration authorization. And this policy also was discontinued by the Biden administration. The transit ban was discontinued. This was a policy that was adopted by the previous administration. It's been revived and slightly modified by President Biden. The current policy, which goes into effect next month, establishes a rebuttable presumption of asylum ineligibility for certain non-citizens who enter the US without immigration authorization at any place on the southwest border other than a designated land port of entry and pursuant to an appointment scheduled through the Customs and Border Patrol mobile application. These citizens also would have to have traveled through a signatory country to the 1951 Refugee Convention and failed to apply for and receive a denial of asylum or other protection in at least one of those countries. Now, because of the time constraints here, I'm not going to go into detail about the specific provisions of the various international law commitments these US policies potentially or clearly contravene. But I do want to point to a few of them and place them within the dominant disinformation themes that swirled around them on social media and legacy media. So as regards the Muslim travel ban, I do want to note that the vast majority of Americans objected to it, as the family separation policy for that matter. But nevertheless, a critical electoral mass does seem to have supported it, based in part, I think, on disinformation that framed adherents of the Muslim faith as terrorists or as insidious influences that would displace the predominantly white and predominantly Christian population of the United States. As I mentioned, the third version of the Muslim ban was Muslim travel ban was upheld under the US Constitution. But there were a number of principles primarily relating to anti-discrimination principles and family protections under the Universal Declaration of Human Rights, the American Declaration of Rights and Duties of Man, the International Covenant on Civil and Political Rights, and the International Convention on the Elimination of All Forms of Racial Discrimination. The threat-based disinformation themes surrounding the family separation policy seem to focus primarily on safety, wealth, and identity. The family separation policy targeted migrants crossing the southern US border. And like the Muslim travel ban, it ran afoul of international law. Just a few of the multiple international obligations violated by this child separation policy include the Convention on the Rights of the Child. Now, the US is not a signatory to the CRC, but its core obligations are applicable to and binding on the United States through customary international law. And so these include things like prohibitions against slavery and against torture, and at least according to some expert, the broader obligation to apply the best interests of the child principle. Other violations were International Covenant on Civil and Political Rights and the American Declaration of the Rights and Duties of Man. The transit ban, running out of time. The transit ban seems to be a policy initiative that arose in a disinformation context involving every threat-based narrative relating to migration: health, wealth, safety, security, and identity. And migrants have long been scapegoated in the US as an outsider group posing a threat to native-born Americans, a supposed threat to native-born American safety and prosperity. And more recently, the disinformation framing has extended to terrorism and threats to national, racial, and religious identity. And the transit ban has been widely condemned as violating the 1951 Refugee Convention and its 1967 protocols, partly because it disregards the legal definition of refugee, which does not require asylum seekers to enter in any sort of lawful manner, and partly because it violates the principle of non-refoulement. Now, we've been talking so far about how migration-related disinformation can indirectly result in the erosion of international law. But the migration-related disinformation itself may also directly contravene pledges, albeit non-binding aspirations under the Global Compact for Migration, as well as obligations under the International Convention on the Elimination of All Forms of Racial Discrimination. So as for the Global Compact for Migration, after the Trump administration informed the United Nations that the US was withdrawing from the pact, the Biden administration reversed course and reaffirmed US commitment to it. And of relevance to this discussion are objectives 1 and 17. Objective 1 is a pledge to collect and utilize accurate and disaggregated data as a basis for evidence-based policy. It also articulates a specific subsidiary commitment to collect, analyze, and disseminate accurate data, and quote, to ensure that this data guides coherent and evidence-based policymaking and well-informed public discourse relating to migration. Objective 17 is a pledge to eliminate all forms of discrimination and promote evidence-based public discourse to shape perceptions of migration. It also articulates specific subsidiary commitments, including to condemn and counter expressions, acts and manifestations of racism, racial discrimination, violence, xenophobia, and related intolerance against all migrants in conformity with international human rights law, and to promote an open and evidence-based public discourse on migration and migrants in partnership with all parts of society that generates a more realistic, humane, and constructive perception of migrants and migration. Objective 17 also includes specific action points, and among them are commitments to quote, promote independent, objective, and quality reporting of media outlets, whether traditional or internet-based, including by, among other things, sensitizing and educating media professionals on migration-related issues and terminology. The other international law instrument potentially implicated, I can get down here. There we go. By migration-related disinformation is Article 4 of the International Convention on the Elimination of All Forms of Racial Discrimination. And Article 4 provides that signatories, quote, condemn all propaganda and all organizations which are based on ideas or theories of superiority of one race or group of persons of one color or ethnic origin, or which attempt to justify or promote racial hatred and discrimination in any form, and undertake to adopt immediate and positive measures designed to eradicate all incitement to or acts of such discrimination. Article 4 also provides that signatories not permit public authorities or public institutions to promote or incite racial discrimination. And the UN Committee on the Elimination of Racial Discrimination, which is the body of independent experts appointed to monitor the convention's implementation, has interpreted Article 4 as requiring that states affirmatively combat speech stigmatizing or stereotyping non-citizens generally, immigrants, refugees, and asylum seekers. And the committee has expressed particular concern about such statements by high-ranking officials. So as the Global Compact for Migration and the Convention on the Elimination of All Forms of Racial Discrimination, then there is a direct line from migration-related disinformation from public officials to the erosion of international law principles designed to protect asylum seekers and other migrants. And arguably, at least, migration-related disinformation disseminated by public officials directly contravenes US pledges pursuant to the Global Compact for Migration and likely violates US obligations under the International Convention on the Elimination of All Forms of Racial Discrimination. And when US asylum policy becomes more restrictive, wholly or partly because of the distortion of political discourse and manipulation of public opinion in response to migration-related disinformation, the shift in policy both reinforces the disinformation narratives and undermines international law principles. So thank you for spending some time with me this afternoon. I look forward to your questions and comments.
Wonderful. Thank you so much. That was phenomenal. So really appreciate your contribution. We'll now move on to our next set of speakers. I did not read one of the speakers' biography in my first introduction, so I'd like to do that now for Ms. Mizu Aziki. My apologies if I'm mispronouncing that. But she is the Deputy Director of the Immigrant Defense Project, and her work focuses on ending injustices related to the entanglement of the criminal and immigration systems, specifically criminalization, imprisonment, and exile due to criminal convictions. Since 1995, she has been organizing around racial justice, workers' rights, and the policing and deportation of immigrants from the United States. She's the founder and executive director of the Surveillance Resistant Lab and a photographer whose work has appeared in Dying to Live, a story of US immigration in an age of global apartheid and policing the planet, why the policing crisis led to Black Lives Matter. So with that, I would like to invite Laura Bingham, Mizu Aziki, and Santiago Narvaez. And my apologies if I mispronounce anybody's name, but I'm excited to hear more about your presentation. And the floor is yours.
Thank you. Okay, I'm speaking first, and I'm just going to share my screen. So, and Mizue is here happily, but also for moral support in terms of speaking. So we're going to divide our time between myself and Santiago, and hopefully we'll hear from Mizue during the Q&A. But the paper that we're presenting is very much a joint project between the three of us. So what I'm basically going to give a little bit of background on the wider project that this paper that we're presenting is a part of. And that wider project was just launched in January. So we're also very much at the beginning of our joint research. And it's led by our three organizations. So as partners, and I should also correct that now Mizue is actually the executive director of a new organization called the Surveillance Resistance Lab. But the work has moved across to the new lab, which also offers a more expansive platform to be exploring various aspects of surveillance technology within the field of migration, but also without. and she can say more about that herself. But anyway, what brought us three together was our interest in surveillance technology and specifically some of our complementary perspectives around the phenomenon that we call border externalization. So I'm going to just be describing very briefly a few of the conceptual aspects of the wider project that are relevant for our paper, and then Santiago is going to delve a little bit deeper into the paper itself. So the paper that we're presenting today is focused on a comparative analysis of what we are calling utopian technologies of digital border control that sit at opposing ends or purport to sit at opposing ends of a democratic stroke authoritarian political and ideological spectrum. And we're using the term utopian here in the tradition of, among others, historian James C. Scott in his seminal work, Seeing Like a State, where he dissects the grandiose, what he calls high modernist schemes in 20th century urban design, and the work that they do, that those projects do in perpetuating nation state ideas and power structures. And so that's why on this introductory slide, we're showing a picture of Le Corbusier's high modernist architecture housing projects as an example of that tradition of utopianism. And the understanding here that we're really getting at is that design itself both reflects ideology and is an instrument of power. In our paper now, and in our project, we're asserting that the design of digital technologies too, and the standards and protocols that shape them display similar properties in terms of how they are vested with ideology and leverage for power, and their impacts also on society at large, individuals and communities can be analogized. And that's even though utopian digital projects, differently from the physical housing structures, are often really abstract and unseen and unknown to the wider population. So I'm going to spend a minute on this concept of border externalization and what we mean by that. And we've found that that's often best done through examples rather than techie language. So first I'll present a quote, which is from General John Kelly, the former Secretary of DHS, of the Department of Homeland Security here in the US, who put it very succinctly and bluntly when he said, quote, "I believe the defense of the southwest border starts 1,500 miles to the south." And a couple of more human stories that we used in our first piece in this project, which we called the Everywhere Border, I think helped to present a more realistic picture, a more humane picture of what General Kelly was getting at. And the first story is that of Fatima Perez and Juan Rufino Ramirez, who are actually depicted on the slide as well. Fatima is a cook and Juan Rufino is a private security guard. They were both arrested in El Salvador and charged with the crime of promoting human trafficking. And that arrest and charge was exclusively based on messages in a WhatsApp group that the two had created in order to coordinate a migrant caravan. Screenshots in Ramirez's case file show that he was giving instructions to members of the group on how to find a bus stop, when to meet, and the price of tickets to Guatemala. Almost immediately after the arrests, the ambassador at the time of the United States to El Salvador promptly congratulated the General Prosecutor's Office in a tweet of her own. And one aspect of this story that we think is important for our understanding of border externalization is the use of mobile phones and other smart ICT connected devices, how they're leveraged for pushing borders out deep into foreign territories. And that's both in the hands, when these devices are sitting in the hands of the targets, and as well as the authorities themselves. The second story that's an illustration for us of what we're speaking about when we're talking about border externalization and digital technologies is that of Roberto M. Also in El Salvador, he was a victim of extrajudicial killing by Salvadoran police in his neighborhood following his deportation from the United States. This act was based on information on gang affiliation that was passed to the local police, the neighborhood police, by U.S. authorities. We know this because his killers threatened a witness to the murder, justifying their actions by saying, "We think that if a person wasn't wanted in the United States, then it must be because the deported person is bad." And Roberto M.'s story in this context illustrates another externalization pattern, one that criminologist Anna Muniz calls borderland circuitry, which is the presence of increasingly interoperable networks of criminal databases that span across borders. They consume policing data. They send it across borders as a routine part of deportation. Many of these databases have been found to contain problematic and unreliable information, but nevertheless, police receive that data on gang member affiliation, biometrics, other biographical information, and what's called derogatory information from the United States, and they share this information with neighborhood level police routinely, where deportees plan to live. So in this context, we've identified in our work to date a number of central observations about the nature and effects of externalization. And this is contextualized to the Americas for us. And I just want to highlight one that is relevant for the paper, which is the dominance of military worldview and ideology in this domain. And for our work, this understanding was contextualized to research in Mexico, where Santiago is based, in Central America and Colombia and parts of the Caribbean, where our research immediately surfaced the integration of new technologies as weapons in successive drug war initiatives in the region. And briefly, I want to describe the second concept before I turn it over, which is the concept of infrastructure. So early on in our collaboration, we concluded that this concept was deeply important to how we understood the phenomena that we were researching and describing and observing. And that's namely the relationship between border externalization, power, human suffering and harm, and resistance. Studies on infrastructure that we started to pick apart and deploy in our research across sociology, political science, science and technology studies have isolated a few key characteristics that sit at the heart of what we believe we're observing. And that includes several things. First, that infrastructure, this is physical or digital, appears to the eye of the perceiver to be motiveless in the sense that it's the work of many hands, but the design or the intention of none. It also in the modernist style assumes that it's given over to scaling. So if you think about the housing projects of high modernist architecture, the idea that they can be replicated anywhere, that they're modular, similar to business models of many modern technology companies. Third, infrastructure also presents itself as somehow inevitable, as if it always needed to be exactly as it's designed, and permanent, and in both respects, also beyond question, beyond challenge, and beyond resistance. So our position is that infrastructure generally and digital infrastructure specifically are contrary to popular comprehension, actually deeply political, and being political, they're deeply laden with political ideologies, and which is a piece of this that's very relevant to our paper. And lastly, an example that we draw on that's also depicted in this map on the slide, it comes from political scientists Marijke de Goede and Carlota Westermeyer, who have a paper on infrastructural geopolitics. And they're looking at US economic power and how that's vested in the financial messaging network called SWIFT, which you may have heard of in the context of the Russian invasion of Ukraine last year, when Russia was cut out really in an unprecedented move from the SWIFT messaging system, because it's foundational really to our modern global financial architecture. But in this picture, what's shown is kind of a heat map of the messages that flow through that system. And you can probably pretty easily see that most of the messages in the blue area are what the authors call the Western industrialized core. And far fewer messages are flowing between that area and large swaths of Latin America, Africa, and the Middle East, which sit in an invisible, largely invisible economic periphery. So our paper, the paper, I'm going to turn it over to Santiago now to talk about the technologies that we're looking at for our paper, but this is just to emphasize that we've already looked at these aspects of digital border infrastructure and power, especially in the Americas and especially for the United States in its geopolitical action. But in the paper that we're presenting here, we really are taking a closer look in line with Professor Breeden's paper at the role of narrative and ideology in the creation of this infrastructure and its justification. And in the comparative analysis that we're doing, we're really looking at these similar sort of high modernist or utopian themes that drive it. And what we're really examining or we're trying to do is to evaluate three things: the relationship between technology and political ideology in the domain of border control. Second, the results and impacts on people's lives of these developments. And third, really at the heart of it is we're looking at the legitimacy of Western narratives that are offered in support of digital border externalization infrastructure. And so with that, I'll stop my share, Santiago, or I can also click for you if you want me to.
As you wish. I can share mine, it's okay.
Okay.
Thank you. Okay. Okay. So I guess you can see my screen there.
Yes, we can see it.
Great. Okay, so first of all, thank you so much for letting us be part of this symposium, including us. And thank you, Laura, for introducing the theme and main like thinking perspectives about what we're going to do. I'm going to talk about more about the technologies or the surveillance programs that we will be talking about in this essay, in this research. So the first one is the non-traveler digital identity, or KTDI, which is an initiative from the World Economic Forum, and it seeks to be a solution for secure and seamless travel authorization it's thought to be based on biometric identification, merging of information about individuals from different sources, originating from both private and public institutions, and also other type of surveillance such as facial recognition. So this is a public-private partnership that will initially involve airlines, hotels, and governments. And there's also an interest in expanding the partnership also to other private and public institutions, such as data brokers, financial services, health and education institutions. The idea is that the individual that uses or becomes part of this program will download an app, put some identification information that will be authenticated by the government. So the governments will be sharing data on the identities of the individuals. And then through biometric and facial recognition, the app will identify the user. Then all this information can be shared with airlines, with hotels, and of course with foreign governments. And the idea is that also the identification will be winning attestations by different institutions, such as I was talking before about education institutions, health institutions. So the idea is that all these institutions share their information that they have from people that want to travel more in a seamless way. This is like an expansion of the Global Pass and of other programs that we have now in different countries to travel and to cross borders like easily. But the expansion of surveillance will be like really important with this program. The next program or surveillance policy that we are talking about is CBP1, like as a starting point. But more generally, we're going to talk about identity dominance led up by the DHS. And when we're talking about identity dominance, we refer to the linking of national security threats individuals, or that are considered like that, to their previous used identities and past activities, particularly as they relate or allegedly relate to terrorism and other crimes. This was developed on the Afghan occupation, the US occupation of Afghanistan, and it was kind of devised as an idea. The objective was to have the data from whole population in Afghanistan. So if they travel to the US to commit a crime or a terrorist attack, they would have their data and they could identify them. Of course, this had like ramifications. After the occupation, Taliban took this system and started using it to identify, to oppress, and to surveil opposition people in Afghanistan. So this is one of the risks that we can see from these systems. Coming back to CBP1, it is a mobile application developed by the US Customs Border Patrol, and that is used for the enrollment of individuals who want to ask for asylum in the US. Since the implementation of the migrant protection protocols in 2019, migrants that come to the southern US border have been forced to stay in Mexico until their case is resolved at immigration courts, and they have to use the app to schedule their meetings. This is becoming like the only way actually for migrants who want to ask for asylum coming to the US southern border, the only way to ask for their case to be heard. And right now, the application only allows 20,000 applications per month. And we have seen a lot of problems regarding the facial recognition technology that it uses. Migrants normally don't have access to, or don't have like that easily access to intelligent phones, or we have seen also that the intelligent phones that they use, the mobile devices that they use, are not being compatible with the use of this application, so they are rendered, they are not being able to ask for asylum. This is, of course, part of the identity dominance that I was talking about earlier from the DHS. and it's part of the creation of systems and databases that capture information from federal, local authorities, also foreign authorities, such as the Mexican government and other governments in Central America, in order to identify all the people that could be like a terrorist risk. There is a question. Okay, so the next, the next system or surveillance that we are.
Sorry to interrupt, Santiago, but if you could finish up the next couple minutes.
Okay.
Great. 3 minutes. 3 minutes. Great. Yeah.
Okay, I will go through it, but. Okay, so the next surveillance system or policy that we're looking about is the social credit scoring, the Chinese social credit scoring that emerged from evaluating business trustworthiness and now is adapted to individuals. In this system, citizens earn or lose points based on actions and behaviors. And in order to do this, the government is using, again, facial recognition, public surveillance, also is looking into information about access to services, to public services, and when a citizen has a low score, they see reduced their access to government services, to jobs, to means of transportation, and also like other stuff like rates, better rates for rent, access to education, among others. The last system that we're looking into is the Uyghur surveillance in the Xinjiang province. This started to develop since 2014, when the Chinese government launched the Strike Hard campaign against violent terrorism and condemned separatist movements and portray them as terrorists. From this moment on, people have been in this province have been under strict surveillance. People's movement is strictly limited to the province, and more than 1 million people have been taken into re-education camps. Again, the government uses facial recognition, data from utilities, internet browsing history, location data, and other stuff to surveil population in these parts. So thinking about how can we compare these mass surveillance systems, I'm not going through all of the table, but for example, it's interesting to see that when we look at the official motivation, 3 of the 4 different surveillance systems, either on Western or on more authoritarian regimes, take security as their main motive. And 2 of them focused on economic gains as well. So regarding criteria, it is interesting to notice how programs apply differentiated treatment to populations that are seen to belong to the countries and those who do not. Then again, both in Western and in China, in this case, people who are seen as populations that do not belong are being treated like second-class humans, and the rights are like being greatly affected by these surveillance programs. Okay, last on the use of technology, we can see that mostly in all of these programs, the technology is the same, yet in the West, surveillance seems to be a bit more limited or not as omnipresent as in China. But then again, there is also a differentiated use depending on whether the objectives of surveillance belong or not to the group. And just to finish, some last general thoughts. We can think that the use of surveillance is bringing states both in the West and in more authoritarian regimes even much closer towards authoritarianism. And we can also think that all of these programs are based on the postulate that Professor Biron was talking about misinformation that states that people are different based on their origin beliefs, and that this difference can be risky, and that we need to know who is different and who doesn't belong to the group to make us safer. At the end, we could ask who is greatly benefited by these systems. Is it the state, the companies, or the people? And also it seems that either way, it doesn't matter to which group as an individual you belong to. We are being more and more surveilled. So thank you. That's all.
Thank you so much. Greatly appreciate your contribution. All of the entire three of you really enjoyed your presentation. Phenomenal presentation once again. And now we will give it over to Professor Wiebe for our final presentation of the day. The floor is yours.
All right, thank you very much. I'm glad there are a few people still around. I will talk about the role of U.S. states in immigration policy, and specifically about driver's licenses and non-citizen voting. And I would like to thank my student colleagues, Ted, Olivia, Brooke, Sarah, Mai Tong, and Samantha, who've done a great job researching a number of these issues, as some of these issues have been a very live, have been very much alive at the state legislature this year in Minnesota. I use this slide to highlight the story of two people I'll call Martin and Zelda. They are clients of the immigration clinic. They moved. They were, as a young couple, they were able to buy a house, which was exciting, and they moved in December of 2019. And as a part of that move, they went to the Department of Vehicle Services and changed their address and got new IDs and driver's licenses. A couple of years later, a year ago, in March of 2022, we were finalizing their applications for citizenship, and there's a question that asks, have you ever registered to vote in the United States? And Martin mentioned that they had gotten some cards in the mail that gave the address of a church. They thought it had something to do with voting, and they just threw the cards away because they knew that they couldn't vote as non-citizens. And so this raised some red flags for us. And we did discover that somehow they had been registered to vote, even though they were adamant that they had not claimed to be a U.S. citizen on any forms. And it was very disconcerting. As we'll see, there are consequences for being registered to vote in both federal and state arenas. So before we finish with Martin and Zelda, just what we'll be talking about today is how to support immigrants while doing no harm. We'll talk briefly about what sanctuary states are, and then move on to driver's licenses for all, improper registration and voting by non-citizens, automatic voter registration, and driver's license for all meets automatic voter registration. So just to refresh people's information bank about unauthorized immigrants in the United States, this just shows the numbers as estimated by the Pew Research Center. And this ends in 2017. I think the estimates are that the unauthorized population is close to 11 million in 2023. But this is sort of a ballpark to give it a sense of how many folks in unauthorized status there are. Now, I think what's a little bit less known is that a majority of folks in unauthorized status have been here for more than 10 years. And that just underscores that this is a sort of a permanent underclass of people who are living in the United States and have vested interests. Often they live in mixed status families in which some are citizens and some are not. And sometimes there are kind of in-between statuses like deferred action for childhood arrivals. So that's just to give a little bit of background. Perhaps a little bit about sanctuary policies by state. This gives a shorthand from the National Conference of State Legislatures of states that are considered pro-sanctuary and states that are considered anti-sanctuary. And this was in 2019. There is some debate over what it means to be a sanctuary state. In some people's vocabulary, sanctuary is a nasty word, kind of along the lines of what Professor Breeden was talking about in terms of conspiracy theories and disinformation. But it is interesting that restrictionist groups and more pro-immigrant groups are kind of in an agreement in which states are pro-sanctuary and which are anti. But what does that mean? So sanctuary really can be thought of in two ways. One is positive measures to support unauthorized immigrants. We'll get into more detail about driver's licenses, also access to public services like healthcare and higher education in particular. Are unauthorized immigrants allowed to enroll and beyond that receive in-state tuition? Are new arrivals welcomed, or are they sort of internally deported, as we're seeing efforts from Texas and Florida to move thousands of people, particularly Texas, move thousands of people from Texas to Chicago or New York or Los Angeles? What about access to professional and occupational licenses? Also, the notion of collective state actions. There are jurisdictions or states that will come together to either support immigrants or to take action against them. So an example is the Deferred Action for Childhood Arrivals program that's before the Supreme Court. Different states have lined up on different sides of that litigation. Also, sanctuary can mean to do no harm. So the notion of disentanglement from federal immigration law enforcement, or on the other hand, to have your own local law enforcement in jails and prisons be deputized by the Immigration and Customs Enforcement to do some of their work for them. It can also be to limit unintentional harm. So we'll talk about voter registration and sometimes how that can inadvertently affect immigrants in negative ways. And also another example would be the impact of criminal sentences. When I say 364 versus 365, what I'm talking about there is under immigration law, it can often make a big difference whether or not a person is deportable from the United States based on the sentence they receive. So in some states, there's an effort to reduce the punishments for a wide variety of crimes from a possible sentence of 365 days to a maximum sentence of 364. And that can make a big difference. This is another way of looking at the notion of sanctuary, and that would be a map of local entanglement with ICE, with the highest level of collaboration and cooperation with immigration and customs enforcement being the jurisdictions in deep red. That would be housing, federally charged folks charged with immigration violations and detained. Often that's done in local jails or state prisons. And then at the other end of the spectrum, for instance, in California and Washington State, policies that prohibit collaboration of local law enforcement with federal immigration law enforcement. So there's a spectrum, and you can kind of see the lighter yellow, Illinois, green, Colorado, New Mexico, California, you can, and some on the in the northeast of the U.S. I'm doing this just to keep people awake. Moving on to driver's licenses. There are 19 states now, plus the District of Columbia, that allow people to get driver's permissions without having to prove a legal immigration status in the United States. On March 7th, the governor of Minnesota signed into law a driver's license for all bill in Minnesota. That's been an effort of 20 years to return to the situation that was in place in 2002, where there weren't requirements of proving legal status in the United States to get a driver's license here. Some of the proponents of these kinds of bills have said that it increases public safety by having people having to take courses, having to have proper insurance for their vehicles. It also is a reduction in the risk of minor law enforcement encounters turning into deportation, because often what has happened is if people are pulled over and don't have proper driver's licenses, they might end up being booked into local jails and immigration enforcement being notified. Part of the driver's license for all bill in Minnesota and in other states, there are concerns about data sharing, that if information about a person getting a driver's license gets transferred to federal databases, that might lead to a targeting of them for immigration enforcement. And then opponents of the bills have often raised concerns about unlawful voting and have pushed that if something like this is going to go into effect, that there are special designations placed on the card, like saying not for voting. There was an effort to get that sort of label attached to the bill in Minnesota, and that was unsuccessful. So here is a map showing the states that offer driver's licenses to unauthorized immigrants. And you can see there are kind of three waves, a few jurisdictions in the 90s and early 2000s, another sort of move in the middle of the last decade, and now there seems to be sort of a regeneration of efforts to get driver's licenses for all. Often this has happened, as in Minnesota, where a trifecta of power between the governor, the Senate, and the House of Representatives in a particular state allows for such legislation to go through, kind of part of the polarization that's gone on in the United States. You can see that the states that have this, there is a loose convergence with the sanctuary states, or that label, and that's not surprising. And just moving on to the improper registration and voting by non-citizens. There are criminal penalties for this. So the reason we're talking about this is that there are, fears, and this kind of goes with maybe some disinformation of non-citizens voting in large numbers. And if you give them driver's licenses, that makes that process easier. It's important to note that there are federal and state criminal penalties. For registration and for voting, and there are also immigration consequences. It can lead to a prohibition on someone adjusting status to permanent residence. It can lead to deportation. It can affect what's called good moral character, which you need to have in order to naturalize in the United States. And that's where the issue came up, and that we're struggling with for Martin and Zelda. But one of the questions is, does unlawful registration and voting actually happen? There's little reliable evidence that surfaced showing significant unlawful voting by non-citizens. For example, one study in 2017 by the Brennan Center for Justice showed that across 42 jurisdictions with that are heavily populated with foreign-born folks, officials who oversaw the tabulation of over 23 million votes in the 2016 general election referred only about 30 incidents of suspected voting for further investigation or prosecution. There have been a small number of prosecutions at the federal level of immigrants charged with crimes of unlawful voter registration and false claims to U.S. citizenship and voting. That's a small number. There were a number of prominent cases in North Carolina in 2018 and 2020, but a relatively small number. Interestingly, Immigration and Customs Enforcement has not made a priority to try to deport immigrants for violating immigration laws. For example, at the start of 2021, there were about 1.3 million people in immigration court. Of that number, 555 were charged with false claim to U.S. citizenship, and there were only 233 for unlawful voter charges. So then kind of the question comes up, why am I even doing anything? In addition, in Minnesota, an audit in 2017 found 31 challenges for lack of U.S. citizenship out of 5.4 million registration records. So it's seems to be a small issue, but at the same time, I've come across anecdotes over decades from many states across the country, from immigration attorneys that have had to unwind or try to unwind these issues. The example of Elizabeth Keithley in Chicago has recently been made into a feature film in which it shows the struggle of this Filipino woman who mistakenly registered to vote while on a K-3 visa after she had told the people at the Motor Vehicles Department that she was not a U.S. citizen. She ended up voting, and she had to engage in a 6-year legal struggle to retain her residency and not be deported back to the Philippines. The numbers are small, but the impact can be very great for the particular individual. So on to automatic voter registration. In 1993, there was a law passed that required states, almost all states in the US, to allow people when they were registering or when they were applying for driver's licenses to also fill out an application at the same time to register to vote. And that's called opting in. over the last few years, 22 states and the District of Columbia have implemented something called automatic voter registration. So in the front end version, you go to the driver's license bureau, you fill out all the information. If you're a US citizen, you have to provide proof that you're a US citizen. And all of that information is automatically entered into the election system unless you opt out at that point of service. Back end opt-out automatic voter registration works the same, but it just happens when you provide this information. And then within 20 days, you get a postcard in the mail saying you will be registered to vote if you don't object within a very short period of time. So in states that have back-end opt-out AVR, for example, in Oregon, 94% of eligible individuals who interacted with the DMV were registered to vote through AVR. In comparison, in California, which relies on front-end opt-out AVR, only about 60% of eligible voters who interacted with the DMV had been registered to vote. Now, the concern, both for immigration restrictionists and for immigrant advocates, is that people who aren't supposed to vote don't get registered because of, for the immigration advocates, because of the criminal and immigration implications of that. There is a debate that I won't get into for consideration of time, that sort of between the back enders and the front enders in terms of AVR. Currently in Minnesota, an back end opt-out AVR bill is moving through the legislature. And in terms of kind of the conspiracy theorists, so this is automatic voter registration, the states that.
If you'd like to finish up in a couple minutes.
Great, I'll do that.
Thank you.
So just to provide a couple of examples, this is a map that shows the states that have both driver's license for all and automatic voter registration. And my question is, this should be the perfect place for lots of immigration fraud or voter fraud. And basically what's been found is that there have been accidental registrations, invitations to register. The undocumented generally aren't included in those mistakes. It's usually legal permanent residence, and actual unlawful voting is rare. So this stuff does happen. I took a look at 4 states, 2 from each type of AVR. And usually remedial measures are taken after there are mistakes, but sometimes the mistakes are, rather startling. Hundreds of people being improperly registered to vote. One thing in Illinois is that it has a separate license system for undocumented licenses that doesn't interact at all with the voter system. In California, there were over 1,500 people who were unlawfully registered and it has a similar different license for the undocumented. I did come across in Oregon, which has a famously safe electoral system. I did come across on a conservative news site the example of someone who moved and got ballots in the mail. And so she thought that she was able to vote and registered. So it was very similar to our Martin and Zelda case. In Colorado, 30,000 people last year who were not eligible to vote received postcards from the state of Colorado encouraging them to register to vote. Once that was discovered, additional mailers went out to say that no, they shouldn't be registering to vote, but it is an example of that happening. So here are just some things about protecting both immigrants and the voting system. And I will allow you just to read those on your own in a few seconds. And I will stop to say that I'll end with Martin and Zelda. We are working hard to prove that they did not intentionally register to vote, and we're going to be trying to help them naturalize with them knowing what the risks are. So hopefully that will end well, but that's yet to be seen.
Wonderful. Thank you so much. I wrote down the name of that movie, so I might give it a watch this weekend. But now we will move into our question and answer phase of our fourth and final panel for the day. So I'd like to invite all our speakers to turn on their cameras back on. And I know Dr. Reed has some questions for each of our speakers, so I'll pass it over to him.
Kimberly, I'll begin with you. Wonderful presentation. Thank you so much for sharing it. And thank you so much for the continuing connection you have to the University of St. Thomas and the presentation on disinformation and immigration. I have a question about just one aspect of it, but something leaped out at me about your presentation. It occurred to me, and that is the idea of moral panic and immigration. I would venture to say we might be in the third great moral panic about immigration. There was the Chinese exclusion cases, of course, in the 1880s. You have this intense moral panic about Chinese and Asian immigration, particularly in the West Coast in the 1880s, leads to all sorts of restrictive immigration law. There's a second moral panic at the end of World War I. Involving particularly East European immigration. And an interesting side note, my mother's family, who came from Eastern Europe at this time, got caught up in that a bit. But I'm here, so I can say we survived. But there was a second moral panic at that time over Eastern European immigration. And I think we're going through a third moral panic now. Are there any connecting threads you might draw between these three great moral panics? Now, Professor Bingham, Professor Santiago Narvaez, thank you so much for your presentation. And Le Corbusier, I'll say about him, utopian, but the other name for his architecture is brutalist, isn't it? I mean, the brutalitarian style, the brutalist style. And you managed to bring out that element also, so thank you. Bring that out in your published work. That there is this ambivalence between the two. Utopian equals brutalist also, and then your presentation very much brings out the idea of extraterritoriality, the extraterritorial reach of law. And as you discussed, the southern extension of borders, I was thinking extraterritoriality. And as I thought about this, I let my mind go to the following set of questions. Extraterritoriality implicates the idea of two different narratives, finally. And one is America as America as unipolar superpower, America as the benevolent, if you will. But then there's the America as the global hegemon. And there are two different narratives at work here. One is a narrative of good order, preservation of trade, and these sorts of things. The other is a narrative oppression, of inability to resist this sort of, and so you have two different narratives operating at an even more fundamental level than the narrative you had developed. So I'm going to ask you if you want to probe that in the final version of your paper. And Professor Wiebe, thank you so much. Thank you so much for helping Martin and Zelda. And thank you so much for the work you do. And I don't have much.
Aren't you going to thank me for my continuing relationship with St. Thomas?
Of course I will. Of course I will. But this is only your first presentation at the JLPP event. Kimberly's done 3. But I just want to say, as I listen to you, I bet you do. Do you do a lot of work with Lindsay Grising? I was going to suggest the two of you should connect if you don't.
Well, we used to teach the immigration law course together.
Okay, because I was saying to myself, yes, as I heard your talk, as I heard her talk, I said, yes, the two of you should really collaborate, and I guess you do. So I'll just leave it at that. So again, Professor Breeden, Professor Narvaez, Professor Bingham, Professor Wiebe, thank you so much for all that you've done today. And I look forward to the final written product from each of you. Thank you so much. Are there any questions from the audience?
Did you ask?
Oh,
He didn't have.
do you have
okay.
any questions?
Yeah.
The speakers.
Oh, there are some online questions.
Okay.
Yeah, that I can. This one goes to Kimberly Breeden for saying that was wonderful. Thank you. Wondering what mechanisms, if any, might be suggested or relevant for holding governments accountable for misinformation.
Yeah, so that's such a great question. And I guess one of the things that I would focus on is the distinction between misinformation and disinformation. Misinformation doesn't include both the deliberate intent to deceive and the intent to harm. And I think there might be frameworks for greater accountability for disinformation than for mere misinformation. Beyond that, I would love to hear some suggestions from experts and practitioners in the field, because this is not an area that I know a lot about. And so I've only just started to think about, well, okay, what's the next step then if there is a similar violation? So I also, if I may respond to Charles, you have to stop putting on such great symposia, right? It's like I'm drawn like moth to flame. But I also do want to thank you for the suggestion.
Put one for November of 2023 also. I'll email you about that.
Oh, okay, great. I'll hopefully have something to contribute then. But I also wanted to thank you for raising the question about the historical threads of moral panics, and that probably beyond the scope of this paper, but might make a separate paper worth pursuing. So thank you for that. And I do think that in terms of the threads to be drawn between the three, I think the threat-based perceptions, whether through disinformation, misinformation, or other kinds of spreading of information to create the kind of concerns or to exploit the fears and concerns of the population does I think link those things together. But thank you for that suggestion.
Dr. Reed, any closing thoughts?
It's been a wonderful event beginning this morning and running on. I began this morning by mentioning Pope Francis and the dedication of his pontificate to a concern for immigration, a concern for refugees, a concern for welcoming those who are unwanted by the world. And I think through the entire course of the day, we've explored different facets of it, different elements of it. And I think we've met, I think by the end of the day, I think I can say we will make, at least in some small measure, a positive contribution. I think we may make things better. I'm not a utopian, I'm not holding out the grand hopes, but we may make things better. So I want to thank each and every one of the panelists for their contributions. Thank you so very much for being part of this. Thank you.
Taylor?
First, I can see that our screen, we are turning green then red. So I'm trying to move as little as possible if the light is reflecting and causing that. Sorry. But as we wrap up today, there are just a few things I want to mention. If you were here in the morning, I said I was going to be thanking a lot of people as we go throughout the day, but I think it's very important to do so, to acknowledge everybody for their hard work and their contributions, for everything that they've put in and done the work for. So I'd actually like to first start off by thanking Rachel Davis Sherp's grandmother for joining us this morning from the beauty salon. Her VIP attendance it should remind us that most of us haven't gotten to where we are today without a ton of support from our networks of support. And I think that's just a great thing to always keep in mind, that it's not just our brains that get us to where we are, it's the people that are supporting us. And so with that, my journal network, support network, as the editor-in-chief over the last year, has been very, very strong. So first, Dr. Reed, who's been my neighbor all day today. He's a great member of our team and someone that has so much knowledge that just describing him as knowledgeable, I don't think even cuts it close. I tried looking up synonyms on thesaurus.com, but I couldn't find anything that fit. And we all just want to thank you for your continuing contributions to our journal. And then another place of support that I've had over the last year is everyone on the journal executive board, like Austin, and then we have Olivia, Chase, Samantha, and that's it. And then in particular for today, our support team for today is the symposium committee. So that is Austin, our symposium director, but then also Brooklyn Collane, Kirby Lee, Hannah Day, as well as Olivia Boyer, who is our incoming symposium director. And if you'd like to see what great things she and her team do for next fall, check out our webpage on the St. Thomas School of Law main site. And who knows, it sounds like you may even see Professor Bree in there for a 4P. Maybe she'll break her own record, who knows? But finally, I'd also just like to thank all the speakers and authors, and we all really look forward to seeing your written work completed. So thank you all, and thank you all for joining us today. Austin?
Yeah, thank you all again. Very grateful and appreciative of all the work you've put in so far and all the work that your articles will contribute not only to your individual academic success, but to our academic success as well. Running the symposium, editing the papers, publishing the articles. We're excited to do it. We're excited that we've been able to share this day with you, and we appreciate you all. Thank you to the symposium committee, all the journal members, Dr. Reed, Taylor Daniels.
Dr.
Daniels. So nothing but thanks, nothing but gratitude. And I hope we all can enjoy our weekend. So with that, you all are free to go. And we thank you again.
Thank you all.
Thank you.